Uh, Good morning, everyone. Good morning, Advocate Watoi.
Good morning, Judge. Good morning to the panel. Good morning to Advocate Chauke and his team.
Good morning, Dr. Chauke. Good morning. Advocate Mutlamanyane. We are supposed to resume from where we ended on Friday. We have seen correspondence between yourselves, the evidence leading team, and Advocate Chauke's representatives. What we are seized with is a purported application to amend. I suppose that it is to amend the terms of reference. We are of the view that if you'd like us to consider your request, you have to file a substantive application for an amendment. If we are to consider this request, failing which, I suppose you know where this request should go to. I'm going to pause there on this aspect, and then you tell us whether we are misguided in relation to the latter suggestion.
Thank you, Madam Chair. May I at this stage point out that actually this application does not emanate from the evidence leaders themselves. It emanates from the NPA, and the NPA would like to address the panel in that regard. Advocate Hali would like to address the panel in that regard, if you allow her. And I'll ask that he be given that opportunity so that you should put it into perspective as to why it had to go through the evidence leaders.
Well, I do not think, even though I've not consulted with my sister, I don't think that's the right way of doing it. If this is a request that we should consider, and I'm speaking to everybody through you have to file a substantive application, because if Advocate Halley is going to address us, he is going to address us as a party himself. And I think all of us know the process, the right process. If a request of this nature has to happen, either through us or directly to the president, through us, through a substantive application, either of the two. So I'm speaking to all concerned counsel through you, and we don't want to belabor this whole process to delay us further, because we cannot engage on letters. That's how we propose we should start. Secondly, we have seen the response from Advocate Chauke. If you have to file a substantive application, they will then have to answer. In that event, we will be able, if persuaded, to present those documents to the minister or to the president via the minister. Alternatively, I think NPA, as he did before, can write to the president and make a proposal. We would like to leave it there so that you can consider during adjournment what option you'd like to take. Then you can indicate to us when you resume.
May I then, Madam Chair, with your permission, inquire as to whether I understand, Madam Chair, clearly. If the NPA wishes to pursue the proposal for the amendment or the application for the amendment with the president, they themselves, the NPA itself, should direct such application or such request to the office of the president and not through the panel here. Did I understand, Madam Chair, to be saying so?
Yes, I'm not here to advise anyone. I'm simply saying there are two options. If you'd like us to consider the contents of the correspondence, you'd have to approach us by substantive application. We need not tell council that. You people are senior councils, you know how to do these things. Alternatively, if we need not consider your request, the option is to start where the MPA started, by approaching the president. The terms of reference are clear. Matters of amendment fall within the space of the president, not necessarily us. But if we are to consider all the things that you are, or the allegation or averments in your request, it should be put in a proper application so that we can consider that. I need not explain myself further.
I hear,
I think all
Madam
of
Chair.
you know what I'm talking about.
Indeed.
Sorry, Madam Chair. I mean, in a sense, it does affect us because any amendment has a knock-on effect. I just want to put that on record.
You need not raise your voice, Advocate Andrew, because if they have to choose. If they need to file, you will have an opportunity to say your piece. At the moment, we cannot speak to the contents of the correspondence. They must file a substantive application if they so elect. If not, they know the route to follow, or should know the route to follow. The second matter, Advocate Mutlamanyane, is the second supplementary affidavit, this big document. It's actually more than that. It was filed of record yesterday. And I'm not sure how you wish to proceed. Obviously, we have not even read this document. But I suppose that you will be able to continue from where you started, or you ended rather, last week, in terms of your initial, or Advocate Batoi's initial affidavit. If my recollection is correct, you paused at paragraph 179, where you were dealing with the opinion, the legal opinion that was presented by Advocate Haile SC. Am I correct? 179 is page 73 of the affidavit of the witness, Advocate Batoi.
You're correct, Madam Chair.
So you may proceed from where you ended and indicate to us how you wish to proceed with these bulky documents that you filed of record yesterday. Secondly, may I know whether Advocate Chauke's representatives have been given these documents?
We received them, Madam Chair, also today, this morning.
You received the bundle today.
We haven't received a physical copy, but it was sent on email. But we can work on the email. But we also got it this morning.
This morning. Council, how do you propose to proceed?
When we consulted with Advocate Batohi on Monday, she indicated that she will not, if my memory serves me well, get into these annexures at any great length, save to point out maybe one or two documents therein. But I got the impression that that is how we will proceed with the document today.
We have not read the document. We don't know why they were filed in the first place. Counsel, I'm sorry, you may confer with your colleague.
My apologies. My co-evidence leader indicates to me that Advocate Hali asked that he go back to his original seat from where he's sitting today, because he thought he was going to address the panel on the issue of the TOR amendments, the proposed TOR amendments.
You may, counsel. We speak to you through the evidence leader, and I suppose you understand our position regarding the request that you wanted to make.
Thank you, Judge. I just didn't want to walk across your line of discussion.
No, by all means.
Thank you, Judge.
By all means, counsel. Feel free. Our chamber, as you can see, ordinarily our clerk should be sitting in front of us. This is not the best chamber that we could ordinarily have had, but we had to make the best of what we have. So feel free, even during the proceedings, if you need to move around, we will understand.
Madam Chair, while we're still discussing the logistics, I just wanted to indicate that I may have to request to be excused precisely to go and prepare what the Madam Chair has talked about, the substantive application and so on, those issues, so that simultaneously, without disturbing the process, we also attend to that. I just wanted to indicate that.
Advocate Skosana, we will excuse you to, if you are still minded to do so, to go and prepare the substantive application. And please serve it timelessly on Advocate Chauke's team so that they can respond timelessly. We will have to talk about time frames. Ordinarily in court, you'll follow the court rules within which to file an answering affidavit, responding to your founding papers. We have not dealt with those aspects in our rules. We did not anticipate an interlocutory application. We may, during a lunch break, have to speak to both you, not lunch break, maybe tea time, talk to both parties with a view to determine orally the time frames that will be reasonable in the circumstances without having to amend the inquiry rules. We will listen to both of you as to the reasonable time that Advocate Chauke will need and the time frames within which you need to file a reply, if any. For now, if it is necessary, you may leave or leave during tea time after our discussion.
Thank you, Madam Chair. I will await the tea time so that, yes.
I think that's the correct approach, so that when you leave, you know within what time period you would file your substantive application, within what time period they will answer, and within what period you will reply.
Thank you, Madam Chair.
Then we can consider your application accordingly. The other matter regarding this bundle, because it was filed of record online, the parties will then have to agree when you are going to be afforded the bundle, the hard copy. We realize that there seemed to be a problem with the printers. It's one of the reasons why we got delayed to come to the chamber. You will agree when you'll have the bundle, if Advocate Mutlamayani is going to take us through the bundle itself as you proceed. My sisters don't have the bundles. I'll have the copy. So both of them would then have to be given the same bundle as I have. For now, Council, you let us know where you would like to begin for today.
May I, whilst
Just before he begins,
Before
my sister.
that,
Advocate Mohlamunyane, you have indicated that in your evidence leading today, you are going to be referring to maybe one or two or a few parts that appear on this supplementary documents that have been provided to us. Is that correct?
it is correct, but it may not even be necessary because the supplementary affidavit seeks to have certain documents filed which were perhaps omitted, and it seeks to put them on record. Certain documents, for instance, the last page of the Ndlondlo affidavit, where it has a signature, to have it on record. That was the main purpose of this supplementary affidavit and these annexes.
Yeah, I'm asking because I see the document appears to be voluminous, right? And if it's voluminous, we would really want to know as to whether, like you are saying, it's documents that are being placed on record for one reason or the other. But then the question is, without speaking to those documents that are in the folder, is it the intention of the evidence leader to have them recognized as part of the evidence without speaking to the specifics in that folder? I just want to understand the intention of introduction of the supplement.
Well, some of them have already been spoken to, but were inadvertently omitted from becoming part of the record. And the supplementary affidavit seeks to have them placed on record. They've already been spoken to. For instance, the last page of the Ndlondlo affidavit, which was the signed page, was not part of the record initially. But my learned colleague, Advocate Nkabinde, indicated that they have the document.
Yeah, I hear you keep on addressing the issue of Ndlondlo, which is quite clear. I mean, it is on record that the signed, the last page, the commissioned last page is available and it should be on record. And that constitutes a page, one page. I want to understand. I understand.
Yes.
Can you just, you know, I don't want to be taken by surprise. Can you just indicate to us as to what other documents, without giving an exhaustive list, but just for us to understand as to which documents were not before us, but have been spoken to and are now necessary to be introduced into evidence into evidence as part of Advocate Batoi's evidence. Thanks.
I hear your concern, Madam Ramagaga. In that regard, may I ask for a short adjournment to take instructions, to line them up with the permission of Madam Chair.
Advocate Mshamanyane, I think we will afford you that opportunity. But just following on the question my sister has posed to you, we were just given this bundle this morning, and we don't know the relevance of this bundle. Secondly, when are we expected to read this bundle in relation to the evidence of Advocate Batoi? So it is important that you guide us. We cannot reach this bundle from page 1 to the end. We don't know what is relevant, what we are expected to do. That's why I indicate to you, you'll have to address us about this bundle. How many minutes do you need?
15 at the most. 15 at the most, Madam Chair.
Chairperson, can I help?
I beg your pardon, Advocate Batoi.
Can I try to assist, because it's my affidavit? I can maybe explain and we can proceed without the adjournment, if I'm allowed to speak.
I think the proper thing is for you to speak to your counsel, to Advocate Mutlamanyane, without us being here, because we don't want to have this back and forth engagement with counsel about what appears to be an obvious thing. It makes it difficult for us to proceed without knowing why documents are placed before us.
I can explain that quite easily, Chairperson.
No, you talk to Advocate Mutlamanyane. He is leading you. I think let's accord him the respect and for him to understand why these bundles have to be used. If they need not be used, the question then remains, why are they filed of record? We already have bundles and bundles of document to read. So talk to him, and as soon as you are ready, you will let us know. We will reconvene. Thank you. Will adjourn. Interim affidavit.
Indeed, Madam Chair.
Please give me a second. Member Council, that I mentioned that we received the documents this morning. My sisters don't have the copies. I suppose you will read, for their benefit, you will read what you are submitting to us because they don't have the bundles. It is because of the lateness and the fact that the printers are giving us a bit of problems. They were able to print one copy, which I have, and you can then refer us to those pages, and if necessary, you can read that document that you are referring us to. Thank you.
Thank you, Madam Chair. I'm reminded by my co-evidence leader that I should inform the panel that Advocate Highly would like to step out to attend to the issue of the TOR amendment. For the rest of the day, he will not be here.
Please, Speaker.
I'm reminded by one of my co-evidence leaders that I should mention that Advocate Highly would like to step out for the rest of the day's proceedings because he wants to attend to the TOR amendment issue.
We are going to take a tea adjournment at 1:15. And I suppose this will be an opportune moment for all of you to decide on that. Advocate Skosana had requested to step out, and I suggested that it be done during a tea adjournment. If you don't come back after tea, we will understand that you are using this opportunity to prepare the substantive application. Will it be okay? Council, Advocate Skosana, Advocate Hale, Advocate Skosana.
It is, Madam Chair. It is fine.
It is because we are not dealing with the evidence. We are dealing with these documents that have just been filed before us. And it may be beneficial to the evidence leader to have you around as we address this bundle. Without going into the details, Advocate Mutlamuyani, you may have to indicate to us whether you want to go through the bundle in its entirety or certain aspects of it, bearing in mind that my sisters. Yeah, that's a document. She has it. Please bear with us. The supplementary affidavit is now filed in our documents. There are annexures thereto, which are filed in this bundle that we spoke about this morning. One of my sisters doesn't have the bundle of annexures. But if you can just indicate to us whether of the documents that are filed of record, particularly the annexures, whether you're going to use these documents in their entirety. It will assist us in preparing. Because what you have done, you filed online of record these documents without us knowing what you intend to do. Ordinarily, you would have handed them from the bar so that you only file the relevant document before us. We don't want to compile a record to the president of documents that were not properly filed before us. I'm sure you understand why that is the case, because what is filed before us online may have to be a record to the president, meaning we have to consider everything that is filed before us. Is that clear, Council?
It is, Madam Chair. Thank
So
you.
indicate to us which of these documents are relevant for your purpose or for the purpose of the Advocate Batoi. Documents that are not relevant may have to be excluded from this bundle. Proceed, sir. It's 11:10. If you can just briefly indicate to us your way forward, we will then take a tea break, then we'll proceed.
Thank you, Madam Chair. As I indicated earlier, the second supplementary affidavit has been filed for the sole purpose of placing certain documents before this inquiry. And these documents are spelled out in this second supplementary affidavit on page 2 and on paragraph 5 of this affidavit. And for convenience, permit me to read the whole of paragraph 5 up to subparagraph 3.
It may be convenient for the witness to speak to her affidavit. You can lead her to speak to her own affidavit.
Advocate Batohi, you have the second supplementary affidavit in front of you.
I do. And Chairperson, I'm still under oath. I will note that.
I beg your pardon, we got carried away to discuss preliminary issues, and it escaped my mind that I should remind you that you are still under oath, Madam.
Thank you, noted, Chairperson.
Thank you, and thanks for reminding me.
May you then kindly read the whole of paragraph 5 up to 5.3 on page 2 for purposes, for record purposes.
Certainly. Paragraph 5. The present supplementary affidavit is delivered for the purpose of placing the following documents before the inquiry. 5.1. All of the annexures attached to the internal memorandum dated 27 June 2019, submitted to me by Advocate R.J. de Kock and other members of his team. A copy of the internal memorandum was attached to my principal affidavit as Annexure SB3. Secondly, the last page of the statement of Colonel R.S. Iyer, attached to my principal affidavit as Annexure SB1 small b. 5.3, the last page of the statement of Bekinkosi Mtiane Dlondlo, attached to my initial supplementary affidavit as Annexure SB11. Should I continue, Counsel?
You may continue to read into the record paragraph 7.
Before you do that, Counsel, I beg your pardon. These annexures, SB3, SB1B, SB11, are they included in the pack that you filed of record this morning? Because I see SB3 in the index at 132 to 228, and SB1B SB1B at 088 to 090, SB11 is indexed at 277 to 282, correct?
That is correct. What has actually happened here is Advocate Batohi's bundle is already on record with her annexures referred to by the acronym SB. Now, SB3 is part of Advocate Batohi's affidavit, which is the internal memorandum of Advocate de Kock. Now, in this second supplementary affidavit, she refers to her original affidavit as the principal affidavit. Now, SB1, it's a statement of Colonel R.S. Ayer, which is attached to her principal affidavit.
No, SB1B.
SB1B, my apologies, I beg your pardon. SB1B, which is on page 090, yes, of the principal affidavit. SB11, which is the last page of Dlondlo's affidavit.
I beg your pardon?
SB11.
Before you go there, SB1B, in terms of the amended index to NDPP affidavit, is at 088 to 090. Is that of the principal affidavit?
That is of the principal affidavit. In other words, this is a continuation of Advocate Batohi's pack of documents. The principal affidavit, including SBs, which were annexures to that principal affidavit. Now, this is a continuation of the pagination that has been done previously and is continued here in this second supplementary affidavit. That is why the first one will be SB 3284, which is on page 007, which is the last page of Dlondlo's affidavit, and it's a continuation. Now it's SB 13. we need to be reminded that the principal affidavit, Madam Chair,
Can I, Advocate Mhlamnyane? Let's go back to SB 1B. In the original, the principal affidavit, it started at 088. That's how we have it. That is Colonel Aya's statement. Start at, yeah, dated the 3rd of August, if I'm not wrong.
yes, Madam
It
Maloi-Mere.
starts at 088, SB 1B 088 to SB 1B 090. Meaning this is a duplication, or was it just an amended index? So yeah.
It is an amended index, Madam.
It's an amended index,
Yes,
so it
Maloi-Mere.
doesn't change anything.
It doesn't.
On this one, it doesn't change anything. And when you go to the internal memo of SB3,
SB3 on the amended index,
starts at
132.
Remember why it didn't start at 132? Because the first 2 pages were duplication. So we
duplicates.
have it on record as starting at 134.
Indeed, that is so.
But maybe before you do that, you proceed with my sister. Why do you include SB1B in the amended index when there is no change in that document?
Well, I haven't taken instructions on that, but I thought the idea was to. I'm speaking for them, but I shouldn't be doing
Don't
that.
speak for them, take instructions. Because
Thank you, Madam Chair.
the very document that I referred you to, SB1B, reflected at 088 to 090, seem not to have changed. It's the same document that has been filed of record earlier. The question is, why did you include it in the amended index? Because you are piling us with documents which are repetitive. Would you please take instructions?
May I?
Yes.
Thank you, Madam Chair.
Yes, sir.
Thank you, Madam Chair. I've conferred with the
Yes, please
NPA
do.
team.
Please do, because I don't understand.
They are saying to me that they have not included documents that were included previously.
Okay.
But all what they intended to do was to do a continuation, but at the same time, an amendment which has to be understood. And if Madam Chair can be referred to SB 13, that's where this additional bundle starts.
Okay.
The principal affidavit ended with SB 12. And SB 1 and its sub-annexures up to SB 12 have not been included in this bundle. All those that are included starts from SB 13 up to and including SB 15G. If that answers the panel's concern, Madam Chair. And may I draw your attention that it's already almost through.
Let me figure out whether I understand you. What you are presenting before us from SB1 to SB12 of the index is merely an index without documentation.
Indeed, Madam Chair.
And what appears from SB12,
From 13.
yes, SB12 or SB13. Look at the previous SB12.
In the original bundle.
That SB12 is a document marked SB12 283.
It ends with 283, Madam Chair.
283.
Yes.
And the current SB12 is the last page of internal memoranda from Advocate Chauke and team panel report dated 27 June 2019. Correct?
That's correct, Madam Chair, where the signature of Advocate Chauke appears.
Yes, it's actually not the 27th of June. It should be 28th of June. If you look at the last page as SB12 283.
It should be 28 June, I agree.
Should we therefore correct the index?
Yes, may it be corrected, Madam Chair. To the extent to which the date is changed to 28 June 2019.
Advocate Batoyi, do you confirm that?
Yes, I do.
SB12, reading, last page of internal memoranda up from Advocate Chauke and team panel report dated 27 June 2019. That document in the original is 28th day of June 2019.
That is correct, Chairperson.
Should it be corrected?
In the index. That is correct, Chairperson.
We have corrected it accordingly. The first document of the new index is SB 13. $284. This is the last document. It is the commissioning document. Am I correct, Council?
You are correct, Madam Chair.
Yes, thank you. It then follows that all the subsequent documents as per the amended index are filed of record.
That is so, Madam Chair.
And I assume that you will then be referring to them as you move forward.
We may be referring to them or we may not, because the majority of these annexures have already been referred to, but the problem was they were not attached to Advocate Chauke's internal memorandum dated the 28th of June, 2019.
Yes, thank you. You'll take us along those SBs when you present the evidence through Advocate Batoyi then.
Yes, Madam Chair.
Thank you for your patience. We now understand why this amended index had to be filed. And we propose that we adjourn, then you can start leading the evidence. Will that be appropriate for you?
That will be appropriate, Madam Chair. Thanks.
Thank you, Counsel. Advocate Skosana and Advocate Halley, you will be excused to proceed with what you intend to do after tea or during tea. We will adjourn for tea. Thank you. Advocate Mutlamanyane. You may proceed. Madam, you are still under oath.
Yes, thank you, Judge.
Thank you, Madam Chair.
Proceed, sir.
Thank you, Madam Chair. We were dealing with the documents that have been filed in terms of what is contained in this second supplementary affidavit. Advocate Patohi, please go to page 3 and at paragraph 11, just read paragraph 11 to the record. Maybe start with 10.
I beg your pardon.
She should start with 10 on page 3 of the second supplementary affidavit.
Second supplementary affidavit.
Indeed,
The
Madam
affidavit
Baloimere.
itself or the annexures?
The affidavit itself, which is page 3. It's called the second supplementary affidavit of the National Director of Public Prosecutions.
Please note that. Perhaps you must hand it up properly and refer to it as an exhibit. That's supplementary affidavit. It's a continuation of the record. You filed it, it's not marked. Are we not supposed to mark it, the affidavit itself? Or will it be marked as an exhibit at a later stage, or what are you going to do?
I never thought it should be marked because it's just an affidavit and it's numbered and it's there, it's numbered and it can be easily accessed and it's easy for one to locate it. I did not have it in mind that it should be an exhibit as such.
Please give me a second. Description on your index. We have by us to show it the original.
Original one.
And the supplementary, where does it appear in your index?
In the index, it doesn't appear. I did inquire, but I was told it has original numbering.
No. Your index refers to the front number 001 to 0081 is the original affidavit. You see in your index.
Yes, in the index, yes.
On the face of the document itself.
I see that, Madam Chair.
My question then is, when you file the supplementary or the additional document, it must also form part of this index so that we know where to find it, as you have done with the first. Doesn't it follow?
It should
Or
have followed.
shouldn't it follow?
It should have followed there.
It should follow.
Yes. It appears to me that has not been done and it's not referred to anywhere else in the amended index.
So when we read this index, we don't know where to find this very supplementary affidavit you are referring to. That's why my sister was also finding out, where do we find it on the pages? But I suppose your junior is here. She must correct these documents and refer to that affidavit, the supplementary affidavit. It's not in the index. But because we have the affidavit itself, you can proceed in the interest of time. Your junior will then have to do the right thing.
Indeed, Madam Chair.
Madam, you are taking note of our challenge. Please prepare a better index and paginate it properly. You may proceed, sir.
Thank you, Madam Chair. Advocate Batohi, I had taken you to page 3, which is the original page 3 of this second supplementary affidavit, and requested you to read into the record paragraphs 10 and 11.
The last page of the land law statement already forms part of the record as A9090 in the bundle titled Documents as per Agreement dated 18 November 2025 - Boyson Racketeering Docket A90. I accordingly attach here to the last page of land law statement marked Annexure SB 14.
Continue to paragraphs 12 and 13.
In my principal
I
affidavit,
beg your pardon. Advocate Batoyi, you are reading from paragraph 11 of the supplementary.
paragraph 10, Chairperson.
Paragraph,
She initially read 10 and then went on to 11 before mentioning that she was reading 11.
yes, thank you.
Yes, 10 and 11, Chairperson.
You may proceed, ma'am.
Proceed
Thank
to
you.
12,
Paragraph 12.
12 and 13, Advocate Batohi.
Certainly. Paragraph 12, in my principal affidavit, I included Annexure SB 3, being the internal memorandum prepared by Advocate Chauke and his team. However, the annexures referred to in SB 3, that is the annexures to the de Kock report as it has been referred to in these proceedings. The annexures referred to in SB 3 were not attached to the affidavit, as several of them already form part of the existing record under other bundles, and one is a High Court judgment. These annexures comprise the supporting documentary material relied upon and referred to throughout the internal memorandum, that is the de Kock internal memorandum. If I may
Just hold it there.
I'm
Allow
trying
the
to-
chairperson and
I'm trying to find my documents. Confusion happens when the index is not properly done, Advocate Mutlamunyan.
I agree. I take the point, Madam Chair.
We at paragraph 13.
May she proceed?
Were we at paragraph 13?
We were at paragraph 13. She was just about to read paragraph 13 into the record.
Yes, you
May-
may proceed.
May you proceed, Advocate Batohi?
Yes, thank you, Counsel. The annexures to SB 3, which are now attached to my present affidavit, are as follows. 13.1, Annexure A, Mosing Affidavit, filed at the State Capture Commission, dated 5 May 2015, and it is in the bundle at LO3, LO 00704 to LO 00720. The second document, 13.2, Annexure B, a copy of the memorandum by the Cater Manor prosecution team, signed by Advocate Maema to Advocate Chauke, dated 29 August 2012. This is in the bundle B5 at B01258 to B01262. 13.3, Annexure C, a copy of the judgment in the Boyson versus Acting National Director of Public Prosecution, 2014-2, All SA 391 KZN, bundle CL 00352. Annexure 13.4, Annexure D, State Capture Commission transcript of Mr. Ngasana's evidence, which is not in the bundle. 13.5, Annexure E, Advocate S. Abraham's affidavit, dated 17 May 2017, which is not in the bundle. 13.6, Annexure F, Advocate S. Maema's affidavit. It's another affidavit dated 17 May 2017, which is not in the bundle. 13.7, Annexure G, a letter to Carl van der Merwe, attorneys regarding the disclosure of the outstanding contents of the court docket, dated 8 May 2013. Chairperson, to the extent that this might be require any further clarity, to say that Advocate de Kock's report is SP3, but at the time of me signing the affidavit, we included the report, but did not include the annexures to the de Kock report. This, in fact, is, besides the two single documents, which are the Commission of Oaths relating to the to Aya and I think it's Blondlo, the rest of the documents are all annexures to the de Kock report, as it has been referred to, and that is attached as SP3 to my affidavit. I hope that clarifies, Chairperson. Thank you, Council.
Thank you, Advocate Batoi. I see, and I'm asking this just for clarity because we have not gone through the documents as yet, but I see that 13.4 that you read into the record, which is Annexure D, State Capture Commission transcript of Mr. Ngasana's evidence. You say it is not in the bundle.
That is correct, Chairperson.
I see in the bundle we have a long document, a transcription, where Mr. Mxolisi Sandile Olifant Ngasana is testifying. Is it before the Zondo Commission?
Chairperson, if I may, which bundle is Chairperson referring to?
It is part of this big document that was presented to us. If you look at SB 15D 376, just after the index, there's a transcription there. That transcript, from the look of things, appears to be a transcript where Advocate Ngasana was testifying. My question is, was it before the Zondo Commission?
That is correct, Chairperson.
Which, if I'm correct, means 13.4, Annexure D, which you have indicated does not form part of the bundle, may be incorrect.
Chairperson, let me clarify. My apologies for that. I was not clear. Chairperson, if you look at 13.1, 13.2, and 13.3, we say it's in the bundle, meaning the bundles that have been uploaded that you have already, they are at those references, 13.1, 13.2, 13.3. You'll see it's in bundle LO or bundle B5 and bundle CL. But I didn't clarify that 13.4, from 13.4, 13.5, 13.6 and 13.7 are not in any of the bundles before before this panel, but they are in this. In fact, this bundle contains all from 13.1 to 13.7, but the first 3 are contained in other bundles. The remaining 4 are not contained in other bundles. I hope I've clarified, Chairperson.
Thank you, Council, which then means, as you have explained, 13.4 Annexure D will be that SB 15D 376 at the beginning of the new bundle, the transcript. Correct?
Just want to check that, Chairperson. 13.5.
Yes, your 13.4,
13.4,
which is, those are new documents
that is correct.
that do not form part of the original bundles.
Any of that is correct, Chairperson.
Yes, thank you. My question then is 13.4 Annexure D should then be your SB 15D 376 of that new bundle. Look at your index.
15D.
Through you, Council. Maybe I should. Maybe I should talk to you.
Maybe I should explain.
No. I don't know what you're explaining. Listen to me first, because I need to clarify my document. Your index is followed by 3 pages. The very first page on that new in that new bundle is marked SB 15D 376. Look at the bundle, Council, not the index. SB 15D 376 is the first page after the index. You have it. I'll speak to the witness through you, then you can just clarify. You have it, Advocate Batoy.
Chairperson, I'm trying to follow here. SB 15D.
SB 15D. This starts here. 333. It starts at page 333. It's padded. Now looking at the new bundle. It's a page which we started taking documents here. Look at the score, that's what it gives. He gives. This is 12 June, day 1. This is SB 15D. That's not signed.
Yes.
And
The stuff there.
Yes. Per there.
Yes, I see.
The index says 333. So it starts here, not from here. Yes.
Thank you. My sister is helping me with the bundling of these documents, meaning the transcript that is referred to in 13.4 Annexure B starts at SB 15D 333.
SB 15D 333 is the start of the transcript of Mr. Ngasana at the State Capital Commission until SB 468.
Yes, thank you. Thank you very much. That makes it easier to follow. You may proceed. May proceed, Advocate Mutlamanyani.
Thank you, Madam Chair. Advocate Patohi, for completeness, go to the next page, page 5, under subparagraph C, and read paragraph 16 up to 16.3 into the record.
Page 5 of the second supplementary affidavit.
That is so, Madam Chair.
Kindly place it on record correctly.
It's page 5 of the second supplementary affidavit of the National Director of Public Prosecutions. Go to
Thank you, Chairperson.
page 5,
Paragraph 16.
paragraph 16, yes.
So it deals with the amended index. And it says at 16, the index to my principal affidavit has been revised to correspond with the fully updated annexure bundles. Chairperson, from what the chairperson herself pointed out, the index does not include my supplementary affidavit. And to that extent, the index needs to be corrected. So I'm not sure that I should read this in, given that we've agreed that there is the index needs to be updated to include my supplementary affidavit.
Subject to what has been
Yes,
indicated.
that is
Yes,
correct.
Yes.
Subject to that, we certainly tried to correctly reflect all the annexures from SB 1 to SB 15, added all the annexures that had previously been omitted, and it reflects corrected and continuous pagination, but subject to the addition of the second supplementary affidavit.
Now, in your testimony, we may or may not refer to the DCOC report. Am I correct?
That is correct. We will likely refer to the DCOC report, but for completeness, given that the report was filed without the annexures, we have now filed all the annexures as well, so that the record is complete.
Having said so, Advocate Patohi, let us then proceed with your evidence in chief. And in this regard, go to page 73 of your original, which you call principal affidavit, in your original bundle, original pack, so to put it, and go back to paragraph 179.
Advocate Mutlamanyani, before the witness takes us through her original affidavit, I'm wondering what it means when you say we may or may not refer to the DCOC memorandum when you've filed the DCOC memorandum. What should we? Should we just wait? It's on a need to know basis, or it will take us by surprise?
No, Madam Baloimere. I wanted to clarify that in certain instances, we will refer to the memorandum, to the memorandum itself. But there will be other instances where it will not be necessary to refer to it. It's not a need to know basis, as put it.
Am I correct, however, that reference was made earlier last week by Advocate Itoy to the DCOC memorandum, which, if my understanding was correct, was the memorandum of the DCOC team that Advocate Batoy referred to quite extensively to her earlier evidence or her previous evidence. Am I correct?
You are correct, Madam Chair.
The memorandum, however, did not form part of the original bundle, correct?
The memorandum itself is marked SB3.
My question, Counsel, is this very memorandum, as Advocate Batoy testified last week, she referred to it, but the memorandum was not filed of record. Am I correct?
Chairperson, it is SB3.
It's SB3,
That is correct, attached to my affidavit.
the original affidavit.
That is correct, Chairperson.
What was not referred to, Madam Chair, with your permission, were the annexures referred to in the internal memorandum of the
Yes, thank
GOGS team
Yes, thank you. But the memorandum was dealt with extensively.
as SB3?
Yes, thank you.
Okay.
Advocate Mutlamnyane, I might have a follow-up question on the GOG memorandum later. I'm just looking at my notes because, and correct me if I'm wrong. Did the GOG's team prepare one memorandum or two? Because I know we were finished with one, and I suspect that I asked a question about the second one, but I'll check on my notes. Just keep that in mind.
Would you perhaps like me to comment on that before we proceed?
Yes, if it will clarify my confusion.
There was another one, which it was a memorandum as well, in which Advocate de Kock did not recommend that the Chauke issue should be referred to the president's office. It has just escaped my mind as to what annexure it is, but it is marked elsewhere. I'll ask my colleagues to assist me in that regard.
Is that the first one?
That is the second one.
The second one?
Yes. The second one.
Yes. And then the first one?
The first one is the de Kock, what used to be referred to as the de Kock report, but we have since coined it as it appears in the documents as the internal memorandum of the Kock team.
Would you please confer with your team, your junior, and take us to those two documents in the bundles so that we can mark them properly?
As it pleases, Madam Chair.
You remember, your team still has to prepare the index that will guide us, the proper index with exhibits. We still don't have that. That's why we get confused. She's trying to talk to you right now. You can just confer with her and just get the pages right for us, because we may be missing something here.
I found the note in my notes. There is, the witness gave evidence that she consulted a panel of de Kock and other people around April 2019. And she said she would still confirm the date, because I've written in red that date still to be confirmed. And then what then followed was received an opinion, which was then called a memorandum from the de Kock team on the 27th of June, I think it's 2019. So there are two de Kock memoranda that we were told about, but one, and then I have a question here. Where do we find this? Because we were not referred to the specific page.
Which one, Madam Maloimere?
The April 2019.
June, should be June 2019.
No, we've got the June. The June we have.
Which is
the 27th of June 2019.
where the team gave this opinion to the NDPP, dated 28 June. Remember, the date was corrected, as the date of signature was the 28 June, but then when they send it through, as appears in SB3, the date appears there as 27 June 2019. But the actual date of signature was 28 June 2019, as previously corrected by Madam Chair. That is the first memorandum, internal memorandum. The second one is contained in bundle C, the bundle called the bundle folder of correspondences. Yes, and it appears on page C 00001.
That is the 15th of February 2023.
Indeed, Madam Baloimere, it goes up to page C 00007, where Advocate Chauke advised and made a recommendation to the NDPP, Advocate Batohi, alone. There was no team here, so if I may, for want of a better term, there was no team here. He was alone when he drafted this memorandum alone. He signed it alone, as his signature appears on page 7 thereof, C7. Does that clarify the status of the two memoranda?
The two memoranda, through you, Chair, and I'm not trying to create a dialogue here. The two memoranda are fine, we have them, but there was a reference to some consultation with the panel in April 2019. And the witness said she's still going to confirm the date. And I made a note, where do we find this? Because we were not finished with that, unless if it was just a consultation, no notes and nothing was finished to us, then I would have to amend my notes. But this is what I have in my notes. That is why in my mind, I remember that there is something to do with April 2019.
My colleagues inform me, lest I be seen to be testifying from the bar, that the date was the 9th April 2019. Advocate Batohi can confirm that a mandate was given to the Chauke panel.
Well, that's when she was giving the instructions.
Yeah, to the Chauke panel.
I'll correct that.
And that brought about the internal memo dated 28th June 2019.
Indeed, Madam Chair, and she can confirm.
That is the first internal memorandum.
Yes.
Of 28 June 2019.
Yes, that is correct, Chairperson. And if I may also mention that Madam Roy Mary is actually correct. I did talk about April sometime when I had thought I had instructed the panel to do the work. We've actually traced the letter that I wrote to them, to the panel. It is dated 9th of April 2019, and it is the letter that I sent to all the panel members requesting them to do this work. I do have a copy of it in my file.
The one that you have now?
Yes.
Yeah, it will later be marked as an exhibit and be handed up. You may proceed.
No. Before you mark it, I think place it on record properly that there is such a letter of instruction by Advocate Batohi to the Chauke team that gave rise to the first internal memorandum dated 28th June 2019. That sequence is critical. If you wish, Council, if you have copies of those documents, that is of the letter of 9 April 2019, instructing the Chauke team to prepare an internal memo, you can then file it of record and hand it up from the bar.
Yeah, I've been furnished with copies, Madam Chair, I think enough copies for the panel and our colleagues. Dated the 9th of April, 2019, and I beg leave to hand it up.
May our judges pay attention, please?
And share through you on the same page. We were promised that we'll get the dates for the review application, because Advocate Batohi said she assumed office in February 2019, and upon her entering the office, she found that there was an application to review Advocate Abraham's authorization of the racketeering certificates. That matter was pending, and she promised to get us the dates of the review.
Would you like to respond, perhaps?
Well, I would certainly, we make a note of it and make sure my team follows up on all of these things so that we don't miss out these things and have to deal with it. So we will certainly apologize for that. It hasn't come through yet. We will get that date. It's easily obtainable.
Now, the document that you say you're having in your possession,
Just come in. You know, I'm getting worried that documents seem to be sprung on us at any time without even either the evidence leader knowing of the intention to use the document, or the evidence leader not having had the courtesy to just advise us about that. And if you look at our record, the transcriptions, they are littered by lots and lots of interruptions, which I believe they could be avoided by proper communication between the evidence leader and the witness, and proper introduction of documents without the panel inviting for the introduction of documents, just like it has happened now. So we would like this inquiry to run quite smoothly. And that can only be achieved if there has been proper consultation and communication between the party and the evidence leader. And moving forward, now speaking for myself, I would really appreciate if the matter were to run that smoothly. And the only way to achieve that would be if there are any other documents that the evidence leader is aware of the intention to introduce them to us, please just enlighten us about that so that we don't stop and go. A lot of time is spent on the stop and go and stop. So like this letter, it was like it's not going to be introduced, and then we see the witness bringing the letter to our attention, whereas it should have been the evidence leader bringing the letter to our attention to say, I have copy of this letter here. Do you have it in front of you? Do you recognize it? Whose letter is that? And then hand it up as evidence without marking subject to later marking. Thank you.
Council, I suppose you have noted the concern raised by our sister.
Yes,
I think we have raised these concerns right from the beginning. It makes our work so difficult. So please, through your team, you have an able team of an SC and a junior counsel. and the support team from the NPA. There's no reason why we should be taken by surprise from time to time. And we pause because we can't be reminding you all the time how you should run this matter. But let's try by all means to make it easier for all of us, and including Advocate Chauke's team. They should be battling the same way we are battling with these records from the NPA. Thank you. You may proceed.
Thank you, Madam Chair. I've taken note of the concerns raised. Advocate Patohi, you indicated there's a document you're having with you.
That's correct.
And remember, your junior should be listening. This is some of the documents that are handed from the bar, which are going to have to be marked as exhibits. Don't forget that, because I don't even know what to call this document. Your index of exhibits should reflect all these documents accordingly. You may proceed, Council.
Thank you, Madam Chair. Which document is it?
It's a document, it's an internal memorandum addressed to Advocate de Kock, to Advocate I. Tenga. Council, it's an internal memorandum from myself. It's dated 9th of April 2019, addressed to Advocate de Kock and Advocate Tenga, Advocate Riley, Advocate Mamabolo, Advocate, and copies to Advocate Mzanyati and Advocate McAdam. And its subject is reconsideration of authorization in terms of Section 2(4) of the Prevention of Organized Crime Act.
Before you proceed to read it, Madam Chair and your sisters, this document will later be handed up and marked as an exhibit.
Well, it is handed up already. All you need to do is to hand the exhibit index referring to all this document, because we have it already.
Okay. Yeah, let's proceed with the document. Can you read the document into the record?
So, I'm reading the contents of the document now. In terms of Section 2(4) of the Prevention of Organized Crime Act, POCA, all racketeering prosecutions must be authorized by the National Director of Public Prosecutions. In this matter, the former NDPP, Advocate Abrams, authorized 2 separate racketeering prosecutions as set out above. The defense have brought an application to have these authorizations set aside, the application in brackets, and the NDPP is a party thereto. As the new NDPP, I am in the process of considering this matter. This is not only because of the citing of the NDPP as a party, but also because of the implications for the NPA. In this case, I've taken note of the controversy surrounding Advocate Abrams' decision to authorize the 2 racketeering prosecutions. His decision has also informed the approach that has thus far been taken in the application. As the new NDPP, in brackets, and now the affected party, I must be satisfied that the prosecutions on racketeering charges in this matter are justified. The decision ultimately rests with me and will also inform the approach that I will take in the application. This specific case and the application present certain complexities and dynamics which could also affect racketeering authorizations in general. In the circumstances, I request your assistance in perusing all the evidence and other relevant material, and thereafter furnishing me with a well-reasoned and motivated opinion as to the validity and appropriateness of the decision by Advocate Abrams to authorize the 2 racketeering prosecutions in terms of Section 2(4) of the POCA in this matter. Please include in your report any factors that you regard as relevant and should be brought to my attention. Advocate McAdam, the Special Director of the PCLU, the unit that was seized with this matter, will be your liaison person. He will assist in collating all the necessary documentation you will need to properly apply your minds to this matter. Maria and Dani will assist with the logistics. I have indicated to the defense that we will revert in the second week of May. Please advise me after you have assessed the work to be done, what you consider to be a reasonable timeline to revert to the defense. It's signed by me and dated the 9th of April, 2019.
Madam Chair, the document will be properly marked and indexed.
If I may just clarify with Advocate Batoi. Advocate Batoi, as at that time, the 9th of April 2019, you correctly, in my view, indicated that the final decision regarding these matters rested with you. Had you been given all the evidential material at that time, or were you expecting the team to put together all the relevant evidential material?
Chairperson, the latter. I was expecting them to do that.
Thank you.
Thank you, Madam Chair. Go back to page 73 of your original or principal affidavit. And when we adjourned last week, we were busy with paragraph 179. You don't necessarily have to read it again into the record, just explain its content.
Council, please speak up so that we can hear you.
When we adjourned last week, we were busy with paragraph 179, and to tie up, you may not necessarily read it again. Just explain its content.
Yes, so just to contextualize, we're dealing with the process relating that led to my referral of the matter to the President. And at paragraph 179, I deal with the issue of the Mdluli matter and having requested an opinion from Advocates Hully and Wenzel, which they did. And following that, I concluded that there was sufficient basis to include this matter in the recommendation to the President.
At the risk of repetition, just to recap where we ended on Friday, it is when reference was made to the legal opinion sought by Advocate Batoi, Madam. And in your testimony, you said that you wanted to make a decision based on evidence. I'm quoting you verbatim as per my notes. And the question then arose, or questions then arose as to whether at that stage, when you sought a legal opinion, you had been presented with evidence to make that decision. If my recollection is correct, and correct me if I'm wrong, you said that you were not presented as yet with the evidence, correct?
That is correct, Chairperson.
And this is notwithstanding the fact that you wanted to base your decision on evidence, correct?
That is correct, Chairperson.
To what extent would a legal opinion have assisted you in forming your decision regarding this matter?
Chairperson, at this stage, if one looks at my evidence that I testified about already, although I had not been placed with the evidence in this matter, I did have Advocate Nalane's opinion in this matter that dealt with both the Boyson matter as well as the Mdluli matter, and recommended a referral to the president in respect of both these matters. Advocate Hali was intimately involved with this. As I said, there was no evidence before me. Advocate Nalani's opinion was before me. Advocate Hali was involved in this matter at the Zondo Commission, and I requested him to give me a further opinion on this matter, so that I had also evidence that I could consider to ensure that I was getting it right. So that's when I requested the further opinion, and Advocate Hali and Wenzel provided the opinion with annexures, and that opinion is in the bundle. I'm not sure if the annexures to the Hali-Wenzel opinion are also included. But as I testified earlier, the annexures included an affidavit or a statement, I'm not sure, by the investigating officer, Colonel Rulofsir, that set out the essential aspects of the evidence.
Thank you, Advocate Batoi. You may proceed, Counsel.
Just before you proceed, I just want to get something right on record. I may have misheard you. As you were reading that paragraph 179, now on the portion that starts with "they did so," do you see that? They did so, and do you see that portion? Yeah.
I do.
Yeah, I think, and I want correction from yourself. I think I heard you say they did so, and I concluded that there was a sufficient basis to include Advocate Chauke. So the purpose, just wait, ma'am. Let me finish my question. Thank you. The purpose of my question now is to find out as to whether, as you were reading this paragraph, you read the I that was not in the paragraph into the paragraph, or if the record will reflect that you said I concluded, that would not be what you said. What is the correct position?
The correct position is that I was not reading the paragraph at all. In fact, counsel made it clear to me, saying, without reading it, can you explain? And so I was explaining.
So in your explanation now, in that explanation, is it correct that you said they did so and I concluded that there was sufficient
That is correct.
basis?
That is correct.
And that I was introduced in the evidence today.
I'm not sure what the panel member means by that.
What I mean is it's very simple. It's what I am looking at as your source of information, as against what you have said. The only thing that I'm concerned with is that I, to understand as to whether when you put the I to say I concluded that, as to whether that was deliberate or by mistake, but it appears from your answers that that was deliberate. Is it correct?
Yes, it is deliberate, because what I was doing is paraphrasing and saying, in fact, if you look at what's in paragraph 179, that seems to suggest that the authors, actually did so and they concluded, right? But what I was saying today is that when I got this opinion, I concluded that they were sufficient.
Yeah. Now, you know, this affidavit, ma'am, it's your affidavit, where you were explaining as to who did what, who said what, and why certain steps were taken. And as you correctly point out, that as one reads this affidavit of yours, as we all know, affidavit is under oath. As you read this affidavit, one gets an impression that they, meaning that team, the team is the one that concluded that there was a sufficient basis to include Advocate Chauke's conduct in the Mdluli matter, right? And I believe that when you drafted this affidavit, you drafted it voluntarily. You satisfied yourself of the contents of the affidavit before you signed it. Is that assumption correct?
That is correct.
And subsequent to you signing this affidavit, which you accepted as correct, at some point now, during this inquiry, the hearings of this inquiry, an issue arose around whether the conclusions relating to Advocate Chauke would have been done by yourself or the panels. And you said you depended on the panels because you trusted the panels. Is that correct?
I'm not sure in what context I said that, but I certainly said that I took into account all of the opinions and when I came to the conclusion that I did.
Thank you.
I have a follow-up question. When you were asked that at this stage, when you asked for an opinion from Advocates Hali and Wenzel, you had not been finished with the evidence. So are you saying to this panel that you read the opinion, and based on the opinion, without having had sight of the evidence, you then concluded that there was sufficient basis to include Advocate Chauke's conduct in the Mdluli matter?
No, Chairperson, that's not what I'm saying. I will repeat what I said. I said that at the time that I asked for the Hali and Wenzel opinion, I had Advocate Nalane's opinion already. And at that point, I did not have any evidence. Advocate Nalane's opinion did recommend that Advocate Chauke, that the matters, the Mdluli and the Boyson matters, be referred to the president. I did not have evidence at that stage. And then I said, given the fact that Advocate Hali was involved in the Zondo Commission and was dealing with these matters, I asked him for an opinion. And so Hali and Wenzel gave me a second opinion, and that opinion also had evidence, some aspects of the evidence attached to it, including a statement by Colonel Rulofsir, which summarized the key aspects of the evidence in the Mdluli matter.
So your decision was taken, or the conclusion that you came to was based on the two opinions, the Nalani opinion and the Hali opinion.
That is correct.
Which we accept that somebody doesn't write an opinion in the sky. The opinion would be based on some of the evidence. So you accepted the two opinions and came to that conclusion based on those two opinions and the evidence that was contained in the opinions without you having gone to the evidence and read it, because that one you've already testified to, and it's accepted that at this stage you had not seen the evidence yourself.
I still think that I'm not clear, so I apologize for that. To the extent that I'm not clear, Advocate Hali's opinion also had annexures, the actual evidence as annexures to his opinion. And I considered the opinion together with the annexures attached to the opinion. And as I said, I'm not sure if the annexures are part of the bundle, but that was what was before me. And included in the annexures was a statement from Colonel Ruloff, sir, which analyzed the key aspects of the evidence in the matter. And there's also other annexures that were attached to that opinion that will be apparent from the opinion itself. So I considered that as well.
Thank you.
May I just follow up you? One or two? Or did you want to? Sure. Okay, thank you. I'm sorry.
Proceed, ma'am.
Okay, thank you. Thank you, Chair. Advocate Batohi, when first, or rather, let me just ask what I think is factual. Is it correct that you first communicated your inclination to recommend the establishment of an inquiry in 2021?
I don't think so. I'm not sure. I do know that in 2021, I wrote to Advocate Chauke asking him for an explanation on various cases, but I did not at that stage, as far as my recollection goes, communicate any inclination to recommend. But I could be mistaken, but at that point, my recollection is that I didn't.
Okay, thank you. I think the correspondence will speak for itself. That's fine. And is it correct that you sent correspondence to the Minister of Justice, Minister Lamola, with an expression of an inclination to recommend that an inquiry be established regarding the conduct of Advocate Chauke?
I did.
And when was that?
I think we have traced that. I'm not sure if it's part of the bundle, but I know that we have traced that letter to the minister or the memorandum. If council can assist me.
You have not yet accessed the
I
document.
think
but
it's SB, I beg your pardon.
Yeah, okay, you've traced
Yes,
that.
I have.
Yeah,
I think I see it
yes.
as SB 10.
SB 10. Yeah?
Yes, and it's dated 18 August 2023.
Yeah. So it was in August 2023 when you expressed your inclination to want the inquiry established. SB 10. 10, yeah. I think I must not look at you, I must look at the documents.
Yes, SB 10 is signed by me and dated 18 August 2023, and it is a memorandum addressed to Minister Lamola. I just want to confirm that. Yes, Minister Lamola, who was the Minister of Justice at the time.
Now, when you sent this when you wrote this memorandum to Minister Lamola, which opinions had you secured then? Whose opinions?
My recollection is that I had all of them. That would be the Nalane one, my Neche, as well as the Wenzel and Hali. That's my recollection. Let me check and make sure. I think that is the case. I would have only done it after. It's not clear from the memorandum, but that's my recollection.
That would be clarified by?
Bear with me for a moment. Yes, it will be clarified by, if you look at SB 10, I go through the document in terms of the, I mentioned the various opinions that I had, and in paragraph 11 at page SB 271, I state that as the NDPP, I requested Advocates Hali and Wenzel, both of whom were evidence leaders in the Zondo Commission, to provide a short memorandum outlining the summary and essence. And their memorandum was also attached and sent to the minister. So I did have that memorandum.
And by
Opinion, I should say.
And by then you also had the memorandum from Advocate Dikok,
Yes.
where he was advising or recommending that the request for the establishment of the inquiry should not be proceeded with.
That is correct. He advised against a referral to the president.
Now, at the time when you send out this request or this memo to Minister Lamola, was this advice by Dr. Dikok, or I beg your pardon, Advocate Dikok, included in the memoranda that accompanied the request or the memo?
In fact, that memorandum was not included anywhere. It was not sent in the bundle, and that's why Advocate Chauke also didn't receive it. And as I mentioned when I was examined about this earlier, it was not included. It was Advocate Chauke requested it, and it was then sent to him, as well as to I think it was sent to the president's office as well at that point. I'm almost sure, but I just need to confirm that.
So your long answer to the question is yes, it didn't accompany the memo.
Indeed, that is my long answer.
Thank you. Thank you.
Advocate Batoi, through your counsel, when was the first letter written to the Minister for Justice? The very first letter regarding the complaint, where the president was requested to set up an inquiry. That would have been the letter, the first letter to Minister Lamola.
That is correct,
Do
Chairperson.
you remember?
Yes, I'm looking at it. I think it's SB 10, and that is dated 18 August 2023.
Sometime in 2021, and please correct me if I'm wrong, I cannot pinpoint to the document in these bundles, but when I read, it appeared that sometime in 2021, there was a communication to Advocate Chauke regarding allegations of misconduct on his part. Am I correct, or am I missing something?
That is your recollection, Chairperson. That letter, I think, is part of the bundle. I think it's one of the annexes.
May I help in that regard?
Help the witness if you have
About
that,
which
that
document it is. Madam Chair, thanks. The document is dated 13 May 2021. Advocate Batohi is SB 5231 in your bundle. And the response of Advocate Chauke.
Before you go to the response, let's look at that letter. SB
5, Madam Chair. 231, it's a page.
SB 5, yes, thank you. SB 5231.
Indeed, Madam Chair.
Yes, dated 13 May 2021.
Ask a follow-up question.
Yeah, wait a minute. And this is the first communication by Advocate Batoi to Advocate Chauke about these allegations. Advocate Chauke requested to provide a response by 31st of May 2021. That's correct, Madam?
That is correct, Chairperson.
From May 2021, I beg your pardon, May 2021, what was this, after the response by Advocate Chauke, what was the next step? I may have to
Chairperson.
put it properly. What was the next step from your side as the head of the NPA?
Chairperson, I'm going to look at my affidavit to refresh my memory. Hopefully that's covered. So, Chairperson, my affidavit at paragraph 161 starts with the process. I'm reading through just to refresh my memory. Chairperson, from my affidavit at paragraph 165, on the 19th of October, Advocate Nalane provided an opinion, so I would have requested that opinion before that date. So that would have been the next step.
Would you have a letter of request to Advocate Nalani, as you have handed the letter of request to the other council for an opinion?
Chairperson, we should have it in the office. We can certainly get that and get the date as well then.
Council, may we, through your junior and the NPA team, be given that letter of request to Advocate Nalani?
That will be done, Madam Chair.
Would you confer with your junior to tell us when we should have that letter? Because I realize that things fall through the cracks. We request for documents, and when we reconvene, you would have forgotten what needed to be placed before us. Let's place you or your team on terms to tell us when they will give us that letter, so that you don't forget. It should be an easy matter to attend to.
Thanks for the indulgence, Madam Chair. They are currently sending a correspondence to the office of the NDPP to inquire about the letter. For the moment, we are unable to say exactly when we will provide the letter, but they will let me know. They'll give me a tinkle in whatever way to let me know that about the answer, what the answer is.
It is important for the purpose of the sequence of events, because when you look at the affidavit 162, reference is made to the response of Advocate Chauke, and then at 165, it was only in 19 October 2021 when Advocate Nalani provided an opinion. In between the dates 28 May 2021 and October 2021, something must have happened between those two dates. A request to Advocate Nalani, it should have been in writing, as was done with regard to others, where Advocate Batoi requested an opinion. I'd like to have a look at the contents of that requesting letter. If your junior counsel can follow up on that matter and give us a copy of that request.
It will be done, Madam Chair.
Thank you, Advocate Msamnya. Advocate Batohi, when you wrote this letter to Advocate Chauke on the 13th of May 2021, the only document or the only information that you had before you was the DCOC memorandum. Am I correct?
The DCOC memorandum was a document that was obtained for a different purpose. But yes, I had it at the time.
Actually, I may not be correct because DCOC memorandum is 28th June. Let me check the year. Or 2019.
That's correct.
So when you wrote this letter to Advocate Chauke, you didn't have the DCOC memorandum.
I think I did, actually.
No, if the
I did.
DCOC memorandum is dated
2019.
29 or
Dated-
2019.
It's dated 28 June 2019.
So you didn't have it, ma'am, before you because this letter is May, June. Chauke's letter. 13 May 2019. Oh, 20, sorry, I mixed up the years. So you had the DCOC memorandum.
That is correct.
And based on your evidence, you had not read the record, you had not gone through the evidence. You relied on the DCOC memorandum, including its annexures.
The DCOC memorandum I relied on for a completely different purpose.
Okay.
Should I explain?
It had nothing to do with so it was not a precursor to what we are
No, it
why
was.
we are here.
That is correct.
So the letter to Advocate Chauke, what prompted you to write the letter to Advocate Chauke, if I may ask?
Well, there were, at the time when I took office, there was, the State Capture Commission was taking place at the time, and there was a lot of public outcry about a number of cases. Now, if you look at the cases that I refer to in the memorandum, I think it's important to understand the context that I actually go to the memorandum itself.
Yes, remember, I've seen, I think it's 5 or 6 cases.
Yes.
Yes.
So I want to explain why those particular cases were included there. The first matter is the Boyson prosecution. And I think we have led a fair amount of evidence regarding this matter. So I asked Advocate Chauke in paragraph 1.2 to explain his reasons for supporting the decision. The next matter is the Mgluli murder matter.
Okay.
And at 2.1, I state, I've perused the NPS representation file relating to this matter. From a reading of the documentation contained in the file, I understand that Mgluli was arrested in the beginning of 2011, whereafter a decision was made to indict him and 3 others in the High Court for several charges, including murder, attempted murder, intimidation, kidnapping. The trial would have commenced in April 2012. But following a representation, you decided to withdraw charges and a formal inquest was held. I then go on 2.2. The failure of the NPA to prosecute Mgluli was successfully challenged. And at a later stage in the same paragraph, thereafter, the prosecution proceeded on charges of intimidation, kidnapping, assault with intent to cause grievous bodily harm, and defeating the ends of justice. No charges of murder were put. The prosecution was successful, and the remarks of the presiding judge in the judgment of the matter relating to the murder are a cause for reflection. Please provide me with the following information or reports and respond to the following issues. Chairperson, I then raise should I read all of those out? I'm happy to do so.
No, you don't have to.
So
I've
that's
read-
what triggered the Mdluli matter.
Okay.
And then there was the other matter, which was a complaint by the late Karima Brown, and she filed a complaint to me regarding intimidation, alleged intimidation. I attached a copy of the complaint to the letter to Advocate Chauke and asked him to respond to the allegations. The next matter was the case of State versus Brian Shlongwa. This matter, this was a matter that General Labia, who was the head of the Hawks at the time, when I took office in 2019, he raised this matter with me as a matter of serious concern, that the matter was in the Johannesburg jurisdiction and had been withdrawn by the DPP. And in his view at the time, the matter was withdrawn, if I recall, around 2012, if I'm not mistaken. So when I met General Labia, it would have been about 7 years later. And his concern was that the matter had been withdrawn and had not been re-enrolled. They had been given to understand that the matter will be re-enrolled. So as a result of this, I then requested Advocate Chauke's reasons for the delay in this matter. And that's in paragraph 4.1. And then the last matter was that of State versus Duduzane Zuma, which was also a matter which the DPP in Johannesburg, Advocate Chauke declined to prosecute, but that matter, Advocate Abrams overturned that decision and in fact took a decision to prosecute that matter. And then in that regard, I asked Advocate Chauke, I state, I have perused the representation file at the national office, but you're kindly requested to provide me with a copy of your office file in which the record of the original decision not to prosecute is recorded, as well as a copy of all related files and information. I'm in possession of your report to the then NDPP in response to his request for a report. The report does not deal with the original decision not to prosecute this matter, and your explanation of this decision would be highly appreciated. So that is the context and the triggers that caused me to request this report, or a report from Advocate Chauke relating to all of those matters.
Thank you.
Advocate.
No. Before I step off this, the next page, SB7, page 261. It's a further letter from you dated the 27th of July 2022. And
That's correct.
At paragraph 4, you say you are inclined to make a submission to the president to hold an inquiry into the fitness of Advocate Chauke to hold office as contemplated in section 12.6.8. That is on the 27th of July. 2022. You had already, and correct me if I'm wrong, you had already formed a view where you say you are inclined, in line with, after careful perusal of Advocate Chauke's responses to your request, you are inclined to approach the president or to make a submission to the president to hold an inquiry in terms of section 12(6)(a) of the NPA Act.
I do say I'm inclined to do that.
And further to that, you went ahead and sought further opinions.
That is correct.
And I might add, without looking at the evidence. Because your testimony is you relied on opinions and their annexures. And you say at the stage when you requested Advocates Halley and Wenzel to give you an opinion, you had not been finished with the evidence, with the facts.
You are correct. At this stage, when I said I'm inclined to, I only had Advocate Nalane's opinion.
Yes.
And I did not have details. I didn't have Dr. Broughton's opinion. I did not have Halley and Wenzel. And there was, on the basis of Advocate Nalane's opinion, I indicate that I'm inclined to do so. But it was not a final decision.
You had the Cook memorandum, Nalani opinion, and my nature that I believe was provided by Advocate Chauke, or was it before that?
I did not have the de Kock memorandum at this stage. I had the de Kock 2019 report, the panel report for a different reason.
Okay.
But with regard to this process,
You didn't.
I only had Advocate Nalane's opinion at this stage. My recollection is that as a result of this letter that I sent to Advocate Chauke, that he then obtained the opinion from Advocate Maineche.
Okay. Thank you.
And after that, Advocate de Kock then sent me the memorandum, just for completeness, if I may. I know I'm inclined to give long answers, so stop me if I'm going too long.
No, yeah, you've jogged my memory that Advocate de Kock gave you a memorandum after seeing the gaps in the Nalani and my nature opinion.
That is correct. So
Thank
I
you.
got that memorandum, and then after that, I got David Broughton's opinion and the Wenzel and Halley opinion. And yes, and after that, I made the referral.
Thank you.
If I may, I know it is almost lunchtime. Council, I'm not sure of the time we normally take lunch, whether it is 1:30 or 2:30. My sisters are saying 1:30.
They are correct, Madam Chair. It's usually at 1:30. But I may proceed. We may proceed until 2:00 if it pleases Madam Chair.
We
and the
will
panel
take a cue
members.
from you.
Yes.
But before we adjourn, if I may just follow up on the last questions, then we'll take an adjournment. Will that be fine?
That will be fine, Madam Chair.
Before, I don't want to derail her train of thoughts on this very point. Advocate Batoyi, it is of concern to me, and I need clarity. When you look at the sequence of events, after you had received the opinion of Advocate Nalane, which I believe was the first opinion. Please don't nod because the record won't reflect your nodding. Please answer.
There was the first opinion.
Yes, indeed. Thank you. And subsequent to Advocate Nalani's opinion, you received, not necessarily in terms of chronology, but you subsequently received an internal memo from Advocate Chauke on the
No.
15th of February, 2023. It was after a number of events where, let me just refer you to this document, maybe you can help. It is a document at C quadruple 1. That document is indexed to folder correspondence. That's the document that we have, indexed to folder and dash correspondence. That document is C quadruple 1, and it is addressed to you by Advocate Andrew Chauke.
I see it, Chairperson.
You see it. In that document, let's look at the subject there. Commission of Inquiry into Fitness to Hold Office in terms of Section 12(6)(a) of the National Prosecuting Authority Act, number 32 of 1998. Purpose. The purpose of this memorandum is to submit a representation to the NDPP, Advocate Andrew Chauke's DPP Johannesburg, in response of allegations of misconduct leveled against him as per report dated 19 October 2021 by Advocate Nalani SC. I won't take you through the entire document, but if you look at page C quadruple 04 against 6.1.12 under the heading misrepresentation to the employer. You see that?
I do.
6.1.12 reads, Nalani's SC's opinion does not specify what clearly much more than that amount to. And Advocate Chauke goes on, in order to rise to the level of unlawfulness, Chauke, as the DPP South Gauteng, would have had to conduct himself such that he exercised the powers in Section 21 of the Act in the National Prosecution that would otherwise have vested in the DPP KZN by virtue of Section 23 of the Act. I'm not going to read the entire part, which is also relevant, but I would like us to go to paragraph 7 at C quadruple 05. Nalani SC refers to paragraphs 180 to 186 of the decision of the High Court in Freedom Under Law versus National Director of Public Prosecutions, refers to the citation there, where the court held that Chauke failed to apply his mind to the relevant considerations mandated by the Constitution and acted capriciously by failing to obtain input from victims and other role players, and further that there was a direct and circumstantial evidence implicating Mdluli, and Chauke could only withdraw the charges against Mdluli in the face of formidable evidence if there were compelling reasons to do so in terms of the prosecution policies, directives. And then he deals with the High Court's decision. I think it is Judge Murphy's judgment. But look at the evaluation, paragraph 11. It is respectfully submitted that Advocate Chauke has overall provided satisfactory response to the allegations leveled against him. for the employer not to proceed with the formal inquiry into his conduct or fitness to hold office in terms of the NPA Act. Advocate Chauke continues. Advocate Chauke denies trying to influence Advocate Mlotshwa improperly in the Katomena prosecutions. It was critical, in my view, for Advocate Nalani SC to interview Mlotshwa with a view to establish the existence of any malicious attempt on the part of Chauke to pressure Mlotshwa to sign the indictment in the Katomena matter. More so, so says Advocate Chauke, Mlotshwa did not seemingly lay any complaint with the employer as an expression of discontent at the time of the occurrence of the alleged offending incident. It is also a well-established principle that issues of discipline ought to be dealt with timely for purposes of achieving procedural fairness. That Chauke apologized to Mlotshwa about an omission by him to provide Mlotshwa with the prosecution memorandum, and that there is no bad blood between the two relatively settles, it is respectfully submitted the matter and further underlines the need for Nalani SC to have interviewed Mlotshwa for the purpose of his report. It also fortifies the principle that discipline must be progressively applied. It is also important to take note that Chauke got involved in the KZN matter at the instance of his senior and supervisor, Advocate Jiva, and therefore the employer, as a matter of practice and the law, the NPPs have in the past assigned prosecutors and even DPPs matters that fell outside their jurisdiction for one reason or the other. Assertions by Chauke regarding his role in the Katomena matter were raised in the context of representations in his defense to the NDPP and has satisfactorily explained his role as that of a coordinating the activities of the prosecution team from his office. An understanding of one's role can, it is respectfully submitted, be subjective and in the absence of glaring evidence of mala fide. It will not be worth pursuing a misrepresentation charge against Chauke. The assertion in the report of Nalani SC that Chauke's role was clearly much more than that, without any indication of what Chauke's exact role was, is rather vague and embarrassing to form the basis of a charge against Chauke. The SCA found Chauke's strategy of withdrawing the charges against Mdluli to hold an inquest not to be rational. Pursuing a charge of distortion of the SCA judgment in respect of the Mdluli case made in the context of representation to the NDPP in his own defense, and where Chauke has made available a copy of the relevant judgment to the NDPP in support of his assertion, is not supported in the absence of a clear evidence of mala fides on the part of Chauke. Besides, the judgment envisaged that the NDPP will reconsider Chauke's decisions to withdraw the case against Mdluli. Recommendation. Advocate Chauke then recommended to you, it is recommended on account of the shortcomings identified in Nalani SC's report, as per the legal opinion of Advocate Maneji, SC, and Advocate Scott, that the NDPP make no submissions to the President for holding of any formal inquiry against Advocate Chauke in terms of Section 12. It goes on. I'm reading this letter or this memo or recommendation by Advocate Chauke. I do know that from the record, Advocate Chauke has since passed on. But this is one of your senior advocates who, with his experience and having served in this office for a number of years, made certain recommendations to you. After these recommendations that seemingly favored Advocate Chauke, following his criticisms of Nalani's report because of his shortcomings, which he points out, and following the SCA decisions that he correctly puts, absolved Advocate Chauke, if I may use the word, because his decision was found not to be irrational. You nonetheless proceeded to obtain further legal opinions. Now, my question follows this backdrop. Why is it so that you were favored with an internal memorandum by an experienced advocate in the NPA? You nevertheless decided to seek guidance from outside advocates who do not necessarily have the knowledge within the NPA. Secondly, why was it important to disregard that opinion and then favored the opinion that seemed to have gone against Advocate Chauke? In other words, you have one opinion by someone within the NPA itself with experience, who had been in that office for many years, who gave you a well-considered opinion, I must say. You may correct me if I'm wrong. And then you went ahead and sought further opinions, and then later seemed to have been persuaded by the subsequent opinions that went against that recommendation of Advocate Chauke.
Thank you, Chairperson. So there's a lot that I need to explain. Chairperson, when I got this report from Advocate Chauke, it is correct that he proposed that there should not be an inquiry into Advocate Chauke's fitness to hold office. And I hasten to add that Advocate Chauke's memorandum expresses a view, and there are a number of opinions that express, legal opinions that express a different view. Chairperson, when I got this, the context of it, you will note from the purpose which you read, was that it was to submit the representation by Advocate Chauke, which was drafted by Advocate Maineche, to me. Because just to explain the process at the time, he was the head of the NPS, my deputy. And so he was coordinating, obtaining certain opinions. So when the Maineche opinion was obtained, it went to his office. And so what he then did is he under cover of this memorandum that the chairperson just read from, he actually attached, he was forwarding me Advocate Maineche's opinion, which I had not seen at that point. He was, yeah, that's clear, I hope. So he sends me the memorandum with Advocate Maineche's opinion. I also have in my possession Advocate Nalane's opinion, which had been sent already to Advocate Chauke. I looked at his response, and there were a number of, what was clear to me is that Advocate Chauke, I beg your pardon, Advocate de Kock seemed to have accepted the say-so of Advocate Chauke on the basis of what was in Advocate Maineche's opinion. And I'll go through some of the details that the chairperson has read out because I think it requires a response from me. Also, he had looked at the two opinions at that time. At that time, he had Advocate Nalane's opinion and Advocate Maineche's opinion. And he based his views on those two opinions and came to the conclusion that they were, for reasons that he sets out here, why we should rather accept Advocate Maineche's opinion over Advocate Nalane's opinion, which had certain shortcomings that were identified. I looked at this at that time, and I realized that Advocate de Kock's evaluation of these two opinions, none of us had looked at any of the evidence, the underlying evidence. And it was clear that
I beg your pardon?
we had not looked at the underlying evidence. So I
I beg your
certainly,
pardon? You say none of that had looked at the evidence. Are you referring to Advocate de Kock, Advocate Maineche, Advocate Nalane?
no, let me rephrase that. Advocate de Kock had not looked at any of the evidence. I hadn't either at that point. I had the opinions. And so I realized that,
I beg your pardon. I'm sorry to intervene. I'm sorry. Remember, this paragraph that I read to you, which is a memo by Advocate de Kock, is dated 15 February 2023.
yes, that's correct.
It is the second, or rather, it's part of the correspondence.
That is correct.
But it comes later, after a couple of years. You remember the first one was in 2019. Am I correct?
You correct. Well,
Let me just get that first. Is the first one 2019?
Chairperson, if I can explain that. That is not, as I said, the first 2019 de Kock report is not, the first opinion to deal with this matter is Advocate Nalane's. The de Kock report, as we've been referring to, which I obtained in 2019, was for the purpose of me trying to establish or determine what approach should I, as the National Director, take in the litigation, the Boyson litigation at that point, which was a review to overturn Advocate Abrams' racketeering authorizations. So in the context of that, I asked the team to look into the matter and give me a view because I needed to decide what do I do with the litigation. So that was a report that was not obtained in the context of considering whether to refer the matter to the president for an inquiry. So just to be clear, Advocate Nalane's was the first opinion that was obtained in this process. But yes, I did have that report at the time.
With relation to the first Advocate de Kock's report that you say had no relevance to the referral or to Advocate Chauke's misconduct, attached to that affidavit that made reference to the litigation, the review application, the racketeering authorizations, etc., there are annexures to that document.
To which document? Sorry,
to
Chairperson.
to the first memorandum.
Yes, that's right. That was what we filed. Let me get I'm getting confused. Today we filed annexures.
To that memorandum.
Yes, that's correct.
Please, counsel, if I am missing something, I see your junior counsel and lady advocate besides you are nodding, meaning they are agreeing with me. The annexures to the first internal memo by Advocate de Kock were filed of record today.
That is correct, Chairperson.
I've not looked intensely to the contents of those annexures, but will any of those annexures form part of the evidence in relation to the matter of Advocate Chauke?
It will, Chairperson. In fact, some of it has already been led. Some of the documents have been referred to already in different contexts.
I want us to get it correct because it's this issue of evidence. Even if the heading might have been in relation to racketeering authorizations, attached to that memorandum as early as 2019, we had evidence, a body of evidence, which allegedly implicated Advocate Chauke, or which may have implicated him or may not have implicated him. But we do know that there was evidence in relation to his matter.
That is correct, Chairperson.
I assume that that evidence, as early as 2019, when you assumed office, when you read it without the opinions of any other advocate, would have assisted you to form a preliminary view about this matter.
That is correct, Chairperson.
Now that you had that evidence in 2019, followed by a lot of correspondence, including this very correspondence I've read to you of 2023, in which Advocate de Kock says, this is Advocate de Kock who had the evidential material in 2019. He now writes in 2023, looking not only at the evidence, but also looking at the judgment of the SCA and critiquing Advocate Nalani's opinion that it is full of depleted with shortcomings, and he draws attention to those shortcomings. Why then, given that scenario by your own advocate who has been in the NPA office, you then even not consider that, but go outside and seek additional legal opinion when the evidence is in front of you?
Chairperson, there were a number of aspects of Advocate de Kock's memorandum that I didn't agree with. And for example, his interpretation of the SCA judgment. And I can go into details. I already had evidence earlier on, but I can deal with it again. But we can park that for now. What I did after this, and you are correct, Chairperson, is that there was a lot of information and evidence that I had that seemed to suggest that what Advocate Chauke did in this matter was not conduct himself, was in fact amounted to misconduct. And the Zondo Commission was ongoing, looking into allegations of capture in the NPA. You're correct. I had the original de Kock report, and there was a wealth of information that suggested. In fact, there was also the Boyson review. That is, I had all of that information, where the Govan judgment also in 2014, I think. So there was a wealth of information that to me seemed to point very strongly at misconduct on the part of Advocate Chauke, notwithstanding what Advocate de Kock said in his report, which, as I said, looked at the two opinions. But you are correct, he also did the 2019 report. So when I got this and having all of that information, also aware of what was going on in the Zondo Commission, at that point, and I need to get the dates right because I'm trying to recall, and these documents do help us. When after I got the Nalane decision, Nalane opinion, we forwarded it to Advocate Chauke. I think it was about a year after we obtained the opinion. And I want to explain what happened in that time as well. After we got the opinion, the Zondo Commission was still doing its work. And I had conversations with Advocate Chauke as well, explaining to him that I was waiting for the outcome of the Zondo Commission when I will decide what to do in this matter, because I knew they were investigating allegations of capture of the NPA or persons in the NPA. The Zondo Commission reports, we got the Nalane opinion. The Zondo Commission reports were released, I think, in 2022, and I must get the dates correct. But in fact, I do mention it in my affidavit. When that report was released, it unfortunately didn't make recommendations and didn't deal with the aspect of capture of the NPA. Although a lot of staff members, as I said earlier, had testified, had made statements, affidavits to Zondo Commission, and I also had all of that information before me, which seemed to show that something seriously untoward and unlawful took place in the NPA. So when I got Advocate de Kock's opinion, I still felt that I needed to properly understand what is the underlying evidence before I make a decision whether to refer or not. And after that, I then looked at, and my evidence is the evidence I'm tendering now is in a vacuum. Perhaps I should not have been the first witness, because there's a lot of other evidence that will be led at a later stage that might actually shed light on why certain things happen. But I don't want to testify about that. But there was a lot of information.
But just on that aspect, Advocate Batoi, I would not imagine anybody speaking before you because you brought us here. It is your complaint to the president that brought us here. And as somebody who has written to the president based on what you presented to him, you will naturally be the first person to come and tell us why we are here.
Chairperson, I'm
not anybody else. So I'm saying, I think it is a misguided statement to say you don't know why you should have been the first witness. I think you are properly before us, madam.
Yes, thank you, Chairperson. It wasn't meant to suggest that, all I was trying to say is that there's other evidence that might contextualize what I'm saying, but that evidence will follow depending on what the evidence leader decides. So when there was a lot of information and evidence, including statements to the Zondo Commission that, as I said, that to me, as the national director, I felt that the matter was still not properly. I did not have the evidence, the underlying evidence, to properly consider whether I should refer this matter or not. There were clearly gaps in Advocate Nalane's opinion. So after I got Advocate de Kock's opinion, memorandum, which expressed his views, as I say, there were a number of things that I can deal with in detail, but at a high level, at that point, I decided I needed to properly understand what is the evidence in this matter. I then asked Dr. Broughton in my office to look at these, I gave him the opinions, and I'm not sure if we've handed in any document that I sent to him or whether it was a verbal instruction, but I asked him to look into this matter and then to give me an opinion. He gave me the first opinion, which was, I think, within a week or little more than that, expressing a view that we should refer the matter to the president, but saying to me that he still felt he needed more time to look at all of the underlying evidence around this matter. For me, it was important that he did that because I wanted to see the evidence before I made this important decision. I then gave him more time. He then went, and his supplementary affidavit sets out exactly what he looked at, what information he had, and he then gave me the very comprehensive opinion, the second opinion, with the full bundle of actual statements, evidence, documents from Zondo Commission, memoranda, and a lot of which we have actually presented to this panel already. But that entire bundle of Dr. Broughton is in fact evidence that I took into account, the hard underlying evidence that led to me also forming an opinion that I had reasonable grounds to believe that this matter should be referred to the president to hold an inquiry into Advocate Chauke's fitness to hold office. And at that point, as I said, all I need, in my view, Chairperson, is to have reasonable grounds to suspect that this is the case. After I got Advocate Dr. Broughton's opinion, as far as the Boyson matter was concerned, I had looked at the evidence. As far as the Mdluli matter was concerned, I still felt I needed to understand this properly. Was there some grave injustice committed? And then I got the opinion of Advocate Hali and Wenzel, who, as I said, were working at the Zondo Commission. And when I looked at that together with the annexures to their opinion, which was some of the evidence, the key aspects of the evidence in the Mdluli matter, I then formed an opinion, in my view, that I had reasonable grounds at that point to believe that Advocate Chauke had in fact committed misconduct, as well as, in my view, there needed to be an inquiry into whether in fact he committed misconduct and in fact he is a fit and proper person to hold the office of a DPP. I made the recommendation to the president, and this part of it is the process in my affidavit, through the minister's office. The president, after his office received what I had forwarded, then requested another opinion. And that my affidavit deals with it. That's another opinion by Advocate Moroka, I think it is, SC. That was not obtained by me. It was obtained by the Department of Justice. And the president, having considered all of this, agreed that there was sufficient, well, I can't speak for him, but on the assumption, because he has decided to hold this inquiry, I can assume, agreed that he was, I don't want to make assumptions for him, but decided that there was sufficient to hold an inquiry into Advocate Chauke's, whether he did in fact commit misconduct and his fitness to hold office. And this, with all due respect, is the purpose of this inquiry, is to establish precisely that. Thank you, Chairperson. I can go into some of the details. You did read out, Chairperson, a number of aspects of Advocate de Kock's memorandum. Perhaps for completeness, I should go to that, Chairperson, and deal with one or two aspects. if I can just be referred to that again, I've closed my page. Chairperson, if I can be guided.
Where do you want to
Advocate
put
Cox memorandum that the
SB3?
SB3.
Yes, in your bundle.
No, the other one, the
The other one is
I think it's SB. No.
it's in C.
Oh, is it in C?
Yes.
Okay. Yes.
Referring to
The second one.
The second, well, his memorandum, it is in C. That's correct.
are you referring to the one that I earlier on read in?
That
It
is correct,
on
Chairperson.
C,
That is correct.
a bundle of correspondence.
Yes, if I could.
C, you can look at it at 0.0000127.
I have it, Chairperson. So if I deal with some of the aspects that the Chairperson read out,
Yeah, I think we may not necessarily deal with them one by one. Those critical aspects, we need not deal with them. I think they were presented as evidence. Most of those aspects, for instance, the SCA judgment, it is
That's
already
correct.
before us.
Mhm.
And those aspects of Mlojua's affidavit, Mlojua's affidavit has been referred to us, if my recollection is correct. Advocate Mlojua's affidavit at the Zondo Commission, I think it has been referred to us. I just wanted to, looking at the sequence and the recommendations as to why, if one of your senior officers, advocates, makes such a recommendation, having looked at the evidence, it was preferable to go outside and seek legal opinions by somebody who are not even members of the NPA. I would imagine the internal experience on matters of this nature will be more helpful than somebody who just look at the law without having the expertise of being an advocate in that office. I may be wrong, but I thought it just made me worry that you disregarded an internal opinion by a senior advocate in the position of Advocate Chauke, who had prepared a document before and then went ahead to seek more opinions. I know that it's clinic time.
Chairperson, there's one aspect that I want to clarify. The opinion that I sought after Advocate Cox was not an external one. It was an internal one. Dr. Broughton is in my office. He is, so I asked him to look at all of this and to get the evidence. So just to clarify, his is an internal staff member, but he is my legal officer and he is in my office and he did the supplementary affidavit.
But you went ahead to get another opinion from Advocate Halley.
Yes, that is correct.
Yes.
I did.
That opinion was obtained 5 months. If you look at the Advocate Cox recommendations of 15 February 2023, and you look at Advocate Halley's opinion of July 2023, about 5-6 months later. And on the 4th of July 2023, Advocate Halley says that they drafted a letter for you in which you were to recommend that the president should institute an inquiry in terms of Section 12.6. So even before Advocate Halley prepared that opinion, he had been asked to settle a letter to that effect. If you look at LO 0010 is volume LO1. That document is the opinion of Advocate Halley. In paragraph 2, in which he refers to you as
Sorry,
our
the page number,
consultant.
Chairperson?
Yes, page LO 001048. It starts at 47. That memorandum.
1048.
Yes.
Okay, that's what it is.
LO.
See, my bundles are slightly different, so I need to go by page number.
Okay. Yes, it's the opinion by Advocate Halley of July 2023, which comes approximately 5 months after the recommendations by Advocate Chauke.
I'm sorry, Chairperson. I'm sorry, the page number, I'm still not there.
It's bundle
You are not-
4.
Sorry?
Bundle 1. Bundle 4.
Bundle
The page number, Chairperson.
LO4.
LO4. I'm
My
sorry.
bundles are organized differently. I
Yes,
need the
it's
page number.
LO4.
Mhm.
Do you have LO4 in front of you?
Chairperson, I have, my bundles are different, so I just need the page number.
Okay. The
And I should be
page
able
is
to.
LO00.
Mhm.
1047.
Let me see now. Halley is LO001048.
1048.
Yes. And this should be the last part because I'm cautioned that it's clinic time. Look at
Yes,
paragraph
I do
2
have it.
there.
Mhm.
On the 4th of July, 2023, that is few months after Advocate Chauke's recommendation, Advocate Halley says he settled a draft letter for the NDPP in which she recommends that the state president institute an inquiry
Mhm.
in terms of Section 12.
Mhm.
You see that?
Mhm.
As at that time,
Mhm.
even before Advocate Halley prepared the opinion in July, you had already formed the view that there must be a referral for the Institute of the Commission of Inquiry.
Mhm.
Yes.
That is correct, Chairperson. So let me clarify this aspect. And I'm thinking back. I'm trying to cast my mind back because it was a long time ago. I'm trying to get the sequence of events correct in my mind. So it is so that by that time, I was satisfied that with regard to the Boyson matter, and that is my recollection, that I was clear about that. That matter needed to be referred. And it is in that context that I asked Advocate Halley to settle the referral letter, if my memory serves me right. That is my recollection. And after that, given Advocate Halley's, during those conversations, given his detailed knowledge of the Bluli matter, I asked him then to provide me with an opinion, and that is when he gave me the opinion with the annexures. Having considered that, I then decided to also refer the Bluli matter. That is the sequence as I recall it.
Yes.
Advocate Batohi, go back to 001048, the letter that was settled by Advocate Halley.
Mhm.
Look at the last paragraph, at paragraph 2, before the subparagraphs. It says the said letter calls into question the conduct of Advocate Chauke in relation to 2 criminal matters.
Mm.
And if you go to 2.2, it talks to the Mdluli matter.
Mhm.
And your answer just now was,
Mm.
at that time, I had already made up my mind about the Boyson's matter.
Mhm.
But the letter that was settled on the 4th of July
Mhm.
already refers to the Mdluli matter.
Mhm.
Do you care to comment on that?
I do. I'm just trying to recall the sequence of events, and it's difficult trying to cast one's mind back, but you are correct. I can only imagine in these circumstances that
Sorry, if I may apologize. Paragraph 4 explains what you're saying. I'm sorry. It says you had already made up your mind about the Katomena, but in relation to the Ramukhibe matter, you were supposed to be provided with. No, but it says with whatever evidence is available to support their process of reasoning. But the letter already contained the matter of Mdluli. So it's like putting the cart before the horse. They settle the letter and then they give you the evidence to support the reasoning.
I can only imagine again that at that point, I was, of course, settling the letter. I was thinking about these matters, and I was very clear about the Boyson matter. And so my thinking, I'm trying to cast myself back, would have been that with the Mdluli matter, even though at that point I had reached some kind of preliminary thinking around it, that I still wanted more. And the purpose of this continuous request for information is because the importance of referring a matter to a president. I wanted to make sure right up until the last moment, before I put my signature on any referral, that I had considered everything that I could before I made this very, very, a decision like this is not taken lightly. This was a very important decision. And so constantly through this process, I'm trying to make sure that I'm getting, that my initial thinking is in fact the right one. So I then in fact ask for more at that stage. And then I'm given, as I said, the annexures with some of the evidence relating to the Mdluli matter. So this entire process is just me trying to forming certain views at certain times, but at the end of the day, trying to make sure that I get it right with the evidence and considering all of that before I made the final referral to the president. So that was why I constantly asked for more, because I had a sense of what was going on. And I felt that as the national director, I needed to make sure that I got as much as possible before I finally made the referral.
Last aspect. I hear you that as regards the Mdluli matter, you still needed some more information, and you were satisfied as regards Katomena matter that the matter had to be referred. The Mdluli matter, and please correct me if I am missing something. The SCA, in the judgment of Judge Brandt, dealt with the Mdluli matter and, in my view, closed the chapter, meaning that, as I understand the judgment, all that needed to be done following the inquest was for the matter to be re-enrolled or for the withdrawn charges to be reinstituted. Am I correct? Just on the reading of the judgment, which judgment seems to absolve Advocate Chauke.
Chairperson, I want to refer to, I did deal with this matter earlier. I want to refer to my notes on this, but my understanding at a very high level of the Brunt judgment is that it did not absolve Advocate Chauke. I don't mean to be disrespectful. I'm trying to find my notes as I speak.
I'm going to request that we park it here. Let's flag that point.
Mhm.
All of us will look at that judgment again and then deal with this aspect because it troubles me.
Important, yes.
And the reason why it troubles me is because an appellate court has pronounced on a matter. And we seem to go against that decision. I just want to understand, in respect of the judgment, did the SCA get it wrong?
Chairperson, we're not saying the SCA got it wrong. Saying
Earlier that you did not agree with certain parts of the SCA judgment earlier.
Chairperson, what I mean to say is that we agree with the SCA judgment, but we do not agree that it absolves Advocate Chauke's conduct.
That is my reading of the judgment. The SCA didn't say I absolve Chauke. The SCA spoke of the conduct of Mr. Chauke or Advocate Chauke not being irrational, if I may use the legal terminology. If his conduct was not irrational, what does it do? It absolves him, in my understanding of the law. Now, I want to understand what is it that the SCA said which disfavored, if I may use the terminology, disfavored Advocate Chauke. When we reconvene, before we all forget, let's look at that judgment and maybe you can assist me in that regard concerning the Ramogibe matter.
We'll do so, Chairperson. This is a very important aspect.
Thank you, very important indeed. Thank you very much. Might I propose that we pause? Advocate Mhlamiyane, I'm sorry that we took a long time on this matter that is worrisome to me, and I honestly need clarity on these aspects. We will reconvene. My sisters are guiding me that we will reconvene at 3:15. Thank you. Good afternoon, Council. Advocate Matlamayani, good afternoon.
Good afternoon.
Advocate Batoi, good afternoon, Dr. Chauke. Remember, you are still under oath.
I do, Judge.
When we adjourned, we were dealing with that aspect of the SCA judgment regarding whether the conduct of Advocate Chauke in relation to the Mdluli matter was irrational or rational. I think if my recollection is correct, the court found that Advocate Chauke's conduct was not irrational. The point I made was, given the fact that the appellate court had pronounced on that matter, was it still necessary to seek the advice of senior counsel in the position of Advocate Halley? Perhaps I should start with the question. By 4th July 2023, you had formed a view that the matter, there should be a referral to the president. Meaning that you had concluded when you asked Advocate Halley to draft the letter to that effect, you had concluded that the matter is worth referring to the president for the establishment of an inquiry. Would you please address us on that?
So, Chairperson, there's two parts. There's two questions that you've essentially put to me. My understanding is you said that I should deal with the second question first. That is, by the 4th of July, I had formed a view for a referral when I asked Advocate Halley to draft the referral letter. Chairperson, by that time, I had certainly formed a view with regard to both of these matters. And if my recollection is correct, I think Advocate Halley settled the draft, not necessarily drafted it. But the position is that, yes, indeed, at that point, I had formed a view that both of these matters should be referred. And at that point, understanding that I had considered the judgments, including the Brunt judgment, and having discussed the matter with Advocate Halley at that point, and given, as I explained earlier, his involvement in this matter at the Zondo Commission with Advocate Wenzel, I asked him for, again, as I said, I was continuously wanting to make sure, even though I had formed opinions at various stages, that I had not signed the letter, this letter hadn't gone off, that I was getting it right. So he then sent an opinion with attachments that I've referred to earlier, which was relevant evidence in that matter as well. So that is with regard to. So the question is whether the relation to the Mdluli matter was rational or irrational. Chairperson, here it's conduct. What conduct was Brunt actually looking at? And I think that is what we need to be.
May we please refer to him as Brunt J or Justice Brunt or Judge Brunt?
Certainly. What conduct was Judge Brunt referring to? And that is what we need to be clear about when we look at the Judge J.A. Brunt decision. So, in my view, Chairperson, is that what Judge Brunt was seized with at that point in time was the rationality of Advocate Chauke's decision not to continue with other charges when he withdrew the murder charge and referred it to an inquest. Brunt J.A. was considering the rationality of that conduct. And it's important that we clarify what exactly was the judge in the SCA considering. And as I said, I agree with the decision of the Supreme Court of Appeal in this regard. Well, we agree, we have no qualm with the SCA decision at all. Brunt J.A. was considering the rationality or otherwise of Advocate Chauke's decision not to proceed with the other charges when he withdrew the murder charge and referred it to an inquest. In this regard, with regard to this conduct, the judge says that Advocate Chauke's reasoning was rational. And in that regard, I agree completely, because having made the decision to proceed to an inquest with regard to the murder matter, it made sense not to proceed with the other matters, other charges, because they were all so intricately linked. The evidence of one was going to support the evidence of another. So at that point in time, Advocate Chauke's behavior or conduct cannot be faulted, because that is the correct, as a prosecutor, experienced prosecutor, that is the right decision. You keep the charges together. And so that, in our view, is what the judges, Brunt J.A., found to be rational.
Let me interpose you there without distracting you.
Mhm.
Whilst you are explaining what Brunt J.A. was dealing with, also have a look at paragraph 43
Of
the judgment of Brunt J.A., which is on page CL 00369 in bundle CL2. This paragraph has already been read onto the record, Madam Chair. But you may look at it, look at the first sentence where it ends, and it may assist you to answer the question.
is paragraph 43, Counsel.
Yes, on page CL 00369. It's actually the
Yes.
second sentence.
Yes.
You can read the first, you can go to the first sentence and the second sentence, where the second sentence ends.
Yes, precisely. The judge states, this brings me to the decision by Chauke to withdraw the murder and related charges. It will be remembered that on Chauke's version, he withdrew the murder charge pending the outcome of the inquest that he had requested, and that he withdrew the 17 other related charges to avoid a fragmented trial. The contention by Full was that this was irrational. So this was the conduct that Brunt J.A. was considering the rationality or otherwise of. And in that regard, the judge found that his conduct was not irrational. And that is fully supported. But the question that we are dealing with in this inquiry, with all due respect, is whether it was whether the decision of Advocate Chauke to withdraw the murder charge in the first instance and then to refer the matter to an inquest was the correct one. And this was not a question that was before the Supreme Court of Appeal. With regard to this question of whether, well, firstly, was the decision of, and I want to preface this to say, Advocate Chauke is a long-standing prosecutor, a very experienced, and he's got a wealth of experience. And we must understand what he was considering and what a reasonable he would have considered at the ages when he made decisions in this matter. The first decision that we must look at is his decision to withdraw charges at a stage when, we must recall, the matter is already in court. General Mdluli is charged for murder and all of the other 7 attempted murder and the 17 other charges that were separated, that is referred to in this judgment. He's charged, he's appearing in court. There is a representation that is made by General Mdluli. The representation does not deal with the merits of the matter. The representation, in a nutshell, alleges I would say, I'm inclined to say far-fetched, but a conspiracy involving a range of people, starting from the police officers, the prosecutors, the witnesses in protection. They are all conspiring, and they've come up with this false case against him. That is the essence of his representation. And I will come to our policy and our policy directives at some point. I don't want to interrupt my train of thought. That talks about how we should approach such representations. In this case, you have this representation. You have Advocate Chauke, who looks at this, an experienced DPP, and you have your team that is saying, this is a strong case of murder, we should prosecute. Advocate Chauke, nevertheless, applying his mind, decides at that point to refer the matter for an inquest. And he states, and I'm going to check because it's either in his response to me, or it could be in some other response that we can find, that one of the reasons why he did this is because, in his view, there could be more inculpatory evidence that will be obtained during the inquest process. Now, the question as a DPP that he should ask at that point is, what more inculpatory evidence was he looking for? On the evidence of the team, you have a strong circumstantial evidence case. What more you have all the witnesses' statements. What more were you expecting any one of those witnesses to say? And that Advocate Chauke can only explain. At that point, the matter is referred for inquest. We get the inquest magistrate. That's the first aspect of Advocate Chauke's conduct that we need to consider, which was not before Branch A. The second aspect is after the inquest is held. The findings of the inquest magistrate is confusing. Advocate Chauke, in his response to me this is an attachment to my affidavit, an annexure. It's SB6 at page 241 and 242. This is Advocate Chauke's response to me in respect of the Richard Mdluli matter. He states that in April 2012, I accordingly decided that an inquest should be held in respect of the murder charge. This is where he says it. My rationale for the inquest was that it might cause inculpatory evidence to surface, which could be used in the criminal trial in respect of the murder charge. I dealt with that aspect of what further inculpatory evidence Advocate Chauke expected in this process that would further strengthen the murder charge. At paragraph 6, he states, the magistrate conducted a formal inquest hearing into the death of Tefo Omar Ramogibe, and in September 2012 concluded that the death of Ramogibe was brought about by unknown persons and cleared Richard Mdluli and others identified. And I stress this, he states, cleared Richard Mdluli and others. I'll get to the inquest magistrate's finding. He does not clear Richard Mdluli, and it's very clear from the language that that is not the case. Advocate Chauke in paragraph 7 then states, I then requested and instructed the prosecution team to enroll the matter in respect of the remaining other charges in which I was satisfied there was prima facie evidence against the accused. What this clearly tells us is Advocate Chauke at this point is of the view that one, the inquest magistrate has cleared Richard Mdluli, and the fact that he wants to proceed with the remaining charges means that he agrees that in respect of the murder charge, he doesn't have enough to proceed. Chairperson, we must therefore now go to the inquest magistrate's findings to show that the inquest magistrate did anything but clear Richard Mdluli of these charges. And if we go to the judgment of, well, it's Murphy's judgment, Judge Murphy as well as Judge Brandt deal with this, but Judge Murphy deals with it more succinctly, and this is in paragraph 72 and 74 of his judgment, which I understand is in CL2, page
Yes.
295.
Yes, Advocate Watoi, I think we have read those judgments.
Mhm.
My question was really directed at that initial stage, the conduct at that stage of provisional withdrawal. I think he used the term provisional withdrawal of the charges.
Mhm.
That's where I'm concerned about. Not necessarily what actually happened thereafter. I think the judgments are clear. Let's look at that conduct when he provisionally withdrew the charges and referred the matter to inquest. I'd like you to deal with that aspect at that stage when he decided to do so.
Madam Chair, with your permission, whilst she's dealing with that aspect of the referral to the inquest, I think it is also imperative that she should refer to the order itself of Branch JA, paragraph 73 of the order itself. Which
You interrupted me. You may ask, because I'm trying to pursue a line of reasoning.
with respect,
I'm not
sorry.
sure what you have in mind. It may be different to what I'm trying to pursue, but she can do that. Counsel, the evidence leader asked that you also look at this. You answer, look at the SCA order.
Yes.
Yes, that may well be. But I'd like us to focus at that stage when he provisionally withdrew the charges pending the finalization of the inquest. At a practical level, when an advocate provisionally withdraws the charges, what is the effect of that? What does it mean? Does it mean the end to prosecution in relation to the provisionally withdrawn charges? Or does it mean what it says, that the charges are provisionally withdrawn with the view that they may be reinstated? I just want to focus on that aspect.
Yes, certainly, Chairperson. You are correct, and we dealt with this in my evidence previously as well, that the effect of a withdrawal or provisional withdrawal is exactly the same. You can reinstate. Prosecutors use the term provisional withdrawal. The effect is not different, but sometimes they use it to kind of give the show an intention to charge at re-enroll at some later stage in the use of the terminology, but the effect is exactly the same. You can re-enroll after a provisional withdrawal or a withdrawal. There's no difference between these two.
Now let's look at the order as Advocate Slamunyane referred us to, and link it with that question and I suppose your answer at CL 00371.
Chairperson, we can go there, but I think that my train of thought, I really wanted the inquiry to hear where I was going with that. But let me deal with this, and then I'll, with your permission, come back to what I was dealing with, because it is critical in my view in terms of the conduct. But we can go to branch JA now. If counsel, you say that is at what chapter?
It's CL is a case law volume 2 of 2.
Okay, I'm there. What page number?
CL2 00371. You see, I asked this question to clear my mind, and maybe other things don't really worry me, but I asked this question to add aspects that continually are worrisome to me, and I want your assistance in that regard.
Understood.
So you can just focus on the question, otherwise you're going to repeat the evidence. So when you look at the order, that seems to link to the question and your answer. Paragraph 3 of the order. Paragraph 54, in the premises, it is ordered that 3, A. Maybe you can read the whole of 3. Let me read it. It is recorded that the following undertaking has been furnished on behalf of the first appellant. A, to decide which of the criminal charges of murder and related crimes that were withdrawn on 2 February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some, if any, of those charges. This means that the order of the Supreme Court of Appeal had to be acted upon by the NPA. So, in relation to the impugned conduct, why is it that the conduct of Advocate Chauke, which constitute a provisional withdrawal of charges pending the finalization of the inquest, was, if I may use the term, unlawful? When the SCA itself says, and you have just indicated, the provisional withdrawal can be amount to a later reinstitution of the charges. Now, the SCA in the order tells the NPA to decide which of those charges it could reinstitute. It was therefore open to the NPA to do exactly that, because the decision of Advocate Chauke, as I understand it, didn't bring finality to prosecution of these charges. You may comment on that.
Chairperson, the conduct that we complain of with regard to Advocate Chauke in terms of what we say is not consistent with the policy directives in terms of what we should consider when deciding to withdraw charges is the following. And this is important because I was going through the various stages of Advocate Chauke's decision making, because it's conduct at the various stages that we are saying. So when we talk about the impugned, I'm not sure I just want to make sure I use the right language, the impugned conduct. We must understand what is the impugned conduct that we as the NPA are saying is the conduct that is problematic, to put it loosely. That is firstly, his decision to refer the matter to an inquest, provisionally withdraw charges and refer to an inquest. That's firstly. Secondly, it's his decision.
Sorry to interrupt you. Can we deal with them one by one? Because when you rattle them like that,
Okay.
you lose us. You say the first one was to refer the matter to an inquest.
That's correct.
An issue that Brand JA dealt with at paragraph 43 and found that decision not to be irrational.
If I could just look at that.
If you can look at line 9, that starts with that line of reasoning at paragraph 43.
I'm there.
That's where Brand JA considered the issue of referral of the matter to an inquest and withdrawing 17 other charges, and also considering Advocate Chauke's reason that he did not want to have I want to use the way that he used that, a fragmented prosecution. And the court further said the postponement of the other charges is not just there for the taking. It might have been successfully opposed by Mdluli himself. So the court found that this conduct was not irrational. And that, if you go to the order by Brand JA, he says the appeal succeeds only to the extent that paragraph B, and B, we know from the court d'accord that it dealt with the decision made on the 2nd of February to withdraw criminal charges of murder, kidnapping, intimidation, assault, and whatever. So that order was reviewed and set aside by the SCA based on the reasoning that we find at paragraph 43, where the judge found that Advocate Chauke's decision was not irrational. And you say that is the first ground of misconduct, if I may use that word, that is impugned upon Advocate Chauke.
It's a minor but important nuance about what exactly is the conduct that we are referring to. In what has been mentioned about what precisely the order related to. The conduct is not, in my view, the conduct is not about Advocate Chauke's decision to withdraw charges and submit it to inquest. Fool's complaint during those proceedings was the fact that Advocate Chauke, this is my understanding, Advocate Chauke did not proceed with the remaining charges when he withdrew the murder charge. Fool was of the view he should have continued with the remaining charges. That was the aspect that Brunt JA was considering, whether his decision to withdraw all the charges was rational or not. And in that regard, Advocate Chauke's explanation that he did not want to have a fragmented trial is absolutely the correct approach. If the decision to withdraw is the murder, the judge, the court was not considering whether Advocate Chauke's decision to withdraw the murder charges was in fact the correct decision. In my humble view, what they were considering is whether there was rationality with regard to his decision to withdraw all the charges because he did not want to have a fragmented trial. And in that regard, it was rational. But the question of Advocate Chauke's decision to withdraw itself was never a matter that the courts were considering. In fact, if we look at the decisions, in my humble view, Judge Brunt is actually quite critical of Advocate Chauke's approach with regard to the murder matter. And that is, I was earlier on going to the various aspects of Advocate Chauke's conduct that we say could potentially amount to misconduct. This is the first one, you're correct. We will move on to the others after we deal with this.
Before we move, let's go back to the High Court decision and look at Order B.
Oh, right, okay. Where will we find that?
It's CL2, page CL00350.
.350.
Yes.
Mhm. Mhm.
That order deals with the decision taken by Advocate Chauke to withdraw criminal charges.
Mhm.
And you submit that that decision was never considered by the court, or it was not before the Supreme Court of Appeal.
I am saying that whether Advocate Chauke took the correct decision in withdrawing the murder charge was not a matter before the court.
Your quibble is in relation to the withdrawal of the murder charge in the face of circumstantial evidence. Correct?
That is the first, yes, that's correct. The first aspect of Advocate Chauke's conduct.
Now, to that first aspect, and we need to get it correctly, of withdrawal of the murder charge for the reasons advanced by Advocate Chauke, in the face of circumstantial evidence. Firstly, it was not conclusive. It was a provisional decision. Secondly, look at 4 of the SCA, the last sentence. The last but one sentence. CL 00369, CL 00369 at paragraph 44.
Mhm.
If you read the last but one sentence, it reads, to the extent that I can read the finer print here, I do not believe the earlier decision to withdraw the charges, which is the impugned decision, can be set aside on the basis that a subsequent decision taken in different circumstances not to reinstate all or some of those charges was not justified. To that extent, the appeal must therefore succeed. What should we make of that?
Chairperson, if you'll bear with me. Can't seem to find my notes that dealt specifically with this aspect, because this is the critical aspect. In my view, Chairperson, and again, this is about interpreting judgments. I think this might be best left for argument, but I'll try my best to deal with it. I do.
Sentence yourself quietly.
Yes, I'll do that, Chairperson.
Yes, I think read that last but one sentence. Branch J is speaking to the withdrawal of the charges, the impugned decision.
Chairperson, I can try now, but let's start from the beginning, if I may, of that paragraph, because I think the context is important. At paragraph 44, Brunt JA states, Fall's real argument, which found favor with the court a quo, paragraph 183, is that Chauke's failure to proceed with the murder and related charges after the findings of the inquest became available was irrational. And that is important. But that decision, that is Chauke's failure to proceed with the murder and related charges after the inquest findings became available, that decision, or his failure to apply his mind afresh to the matter after the conclusion of the inquest, was not the subject of the review application. It will be remembered that the review application started in May 2012, while the results of the inquest only became available in November of that year. Stated somewhat more concisely, I do not believe that the earlier decision to withdraw charges, which is the impugned decision, can be set aside on the basis that a subsequent decision, that is the subsequent decision not to proceed with the murder matter after the inquest findings became available, that a subsequent decision taken in different circumstances not to reinstate all or some of the charges was not justified. So my understanding, and then the judge goes on to say, to that extent, the appeal must therefore succeed. So my understanding and interpretation of this, Chairperson, is that what the judge is saying is that Advocate Chauke's, what was not before the court was Advocate Chauke's failure to apply his mind afresh after the conclusion of the inquest. And that was not before this court. And my understanding of what Full was trying to what they in fact put forward in this second supplementary affidavit, which was filed after the inquest findings became available, bearing in mind that the first was before, was after the inquest findings became available, they put in a supplementary affidavit alleging this. But my understanding is it was not part of the relief that was sought. And on that basis, the judge finds that I do not believe that the earlier decision to withdraw the charges, which is impugned decision, can be set aside on the basis that a subsequent decision taken in different circumstances, not to reinstate all or some of those charges, read in after the inquest findings, was not justified. To that extent, the appeal must succeed because that aspect was not before the Supreme Court of Appeal.
I'm not sure whether I follow what you're saying, but let's just assume that you are correct in your statement or your evidence to the effect that the impugned decision we are concerned with here, it is the withdrawal in the face of circumstantial evidence. Let us assume that. But how often do prosecutors assess or evaluate cases when confronted with circumstantial as opposed to direct evidence and decide in these circumstances of circumstantial evidence, I will provisionally withdraw charges until further investigation is done? What is unlawful about that? When you evaluate the evidence, which is not direct, but circumstantial. And all of us know as lawyers is how difficult it is to make decisions on circumstantial evidence. Now, if a prosecutor is confronted with circumstantial evidence and provisionally withdraw the charges based on the circumstantial evidence, what is unlawful about that?
Chairperson, we're not saying there's something unlawful about it.
Let me rephrase that, thank you. On what basis then should such a prosecutor be said to have misconducted himself to the extent that he should be suspended or should lose his employment, possible employment, or should be disciplined?
Thank you, Chairperson. That's a very important question. It's critical because this is not a...
That is why I asked the question, because I thought so.
I won't say anything to that, Chairperson. Thank you very much. It is a very important question. I agree with you. Prosecutors in their daily jobs, it happens. It happens that you are required to consider evidence, circumstantial evidence, and make a decision of whether you proceed on the basis of that evidence or you don't. And certainly, it's not in every case where a prosecutor decides not to proceed with a case based on circumstantial evidence that there will be a consequence like a disciplinary process that follows. And that is because, Chairperson, each case has to be considered on its own merits. And if we look at the particular circumstances of a case and we say, okay, we can understand why the prosecutor would have done this. Reasonable minds could differ. That is, of course, you are never going to discipline a prosecutor because that's totally understandable. And I would never want prosecutors to be fearful of making the correct decisions based on the evidence before them. And I must go back to our policy directives in this regard because it talks to us, it helps us to make these decisions. But where you have a case of strong circumstantial evidence, I've got in my bundle here where I think it's de Villiers, and there's also case law that talks about the strength and power of circumstantial evidence. And
Who makes the call as to whether the evidence is strong or weak?
Chairperson, the prosecutor, him or herself, must do that. You are faced with the case, you are the one that makes the assessment, and you take a decision. And if that decision is justified on the basis of the facts of that case, well and good. Withdrawal in the face of circumstantial evidence that doesn't quite reach the threshold is perfectly acceptable. But as I said, you have to look at the circumstance of each case. In this particular case, Chairperson, what we are saying is, we are saying that this was a case that had strong, you have degrees of circumstantial evidence. You can have weak circumstantial evidence, strong circumstantial evidence. Where does it fall in this band? In this case, according to the prosecutors, the team in this matter, they were of the view the case is strong. The circumstantial evidence is strong. But the DPP, an experienced prosecutor of long standings, who is a good prosecutor, decides in the face of, you've got to then look at the facts. There was a representation. All that the representation did was allege a bizarre, in my language, conspiracy. In fact, when the accused was, Nduli was finally charged in the decision of Judge in the High Court, I have it here somewhere, in the decision of Judge Mokhatleng, he found that that conspiracy was completely baseless. But let's not go down a rabbit hole. Let's come back to your question. When in this particular case, you have a strong circumstantial evidence, you have a representation that alleges a conspiracy amongst a whole range of people, and that is why I am being falsely framed in this. Now, I do want to pause here to go to our legal framework to see what it says about how we assess cases when we deal with withdrawal of matters. And I have it somewhere on my desk. I would ask for a few moments to get that, because I think it's really important that this be factored into our consideration of this matter.
So I'll ask Advocate Motlamunyane and the junior to assist Advocate Batoi to look at that in the meantime.
Okay, so I will continue then.
Yes, as you pause, just on that aspect, I want us to work on the assumption that you are correct. Advocate Chauke made a mistake or misconducted himself by withdrawing the charges in the face of circumstantial evidence. Let's say you are correct. Shouldn't much more be established to warrant a suspension of an advocate or prosecutor who makes a mistake of that nature in the absence of bad faith on his part? If it is not established by way of evidence that this particular advocate acted in bad faith in making that mistake, will any subsequent suspension or disciplinary hearing be warranted?
Chairperson, if I got you correctly, are you saying if it is established, if it's not established by way of evidence that the prosecutor acted in bad faith, will any disciplinary proceedings be warranted?
I'm making an assumption in
Yes,
favor
I get
of
that.
your proposition.
I get that.
If your proposition is correct, and yet there is no evidence to establish the bad faith on the conduct of the particular prosecutor, will his conduct warrant a suspension or a disciplinary hearing against him?
Chairperson, if there is no evidence or suspicion of bad faith,
No mala fides
if there's
on
no
his
mala
part?
fides at all, it should not attract any disciplinary processes.
In that event, will that not then require the NDPP to bring forth evidence establishing the bad faith, the mala fides on the part of this advocate?
Chairperson, let me think about this, because there's a lot in this case. And I want to make sure that when I answer correctly. I would say there's a difference between acting mala fides and not acting in accordance with the requirements of our policy and policy directives. And even though there may be no mala fides, and I'm not for a moment saying that is a conclusion in this matter, but even though, just speaking hypothetically, there's no mala fides, you have to look at what was before the prosecutor at the time. Chairperson, let me go to our policy directives. And I think it will, because there's a fine line between mala fides is strong, and there's also where you do not apply your policy guidelines and prescripts in a way that you'd expect an experienced prosecutor to do. So I think I need to be clear about that. In this particular case, Chairperson, there's evidence that we had led, that I spoke about earlier, about 3 cases involving General Mdluli that all got withdrawn in different contexts. This is one of them. There's another one involving the fraud matter in respect of the State Security Fund. There's also the disciplinary proceedings in the police. There's also...
But those do not relate to the matter we are with. Let's focus on this one. I remember that matter of Advocate Murwebi and others. Let's focus on this particular one. Because, and I may be wrong, we hear of many charges being withdrawn against people. Many, many, many. Prosecutors withdraw charges.
Mm-hmm.
It's not something new,
Mm-hmm.
even in some of the high-profile matters.
Mm-hmm.
And my statement to you, my proposition is, let us assume you are correct, that the charges ought not to have been withdrawn in the face of the circumstantial evidence. Let us assume in your favor.
Mm-hmm.
But shouldn't there be more than just an accusation that you ought not to have withdrawn the charges? Shouldn't the bad faith on the part of the prosecutor be established for the person to be dragged to a disciplinary hearing and be suspended? Because it seems to me, if that were the case, many prosecutors will be suspended or will be investigated without direct evidence of mala fides in the actions they took. And of course, you are going to address us on the policy directive.
Mm-hmm.
But I would like us to look at the evidence that is suggestive of the fact that Advocate Chauke acted in bad faith?
Chairperson, the issue of intention of a person, whether it's in good faith or in bad faith, is often a deduction based on a range of factors. You come to the conclusion that someone has acted in bad faith because it's not direct evidence. You have to look at various things that someone has done before you conclude that there was perhaps an ulterior motive here, because a reasonable person in this circumstances would have done 1, 2, and 3. This person in these circumstances does 4, which you cannot understand. And when there's a range of those things, you can then begin to infer whether a person is acting in good faith or in bad faith. In this particular case, there's a range of those touch points where we say is indicative of the fact that Advocate Chauke behavior was not what it should have been, what a reasonable DPP in his position would have done, and was it being driven by any ulterior motives? And I need to touch on those important points at which he exercised his discretion and what his decision was in this case. I had touched on the first point, the first decision.
Just remind me.
That was the one where he decided to withdraw charges and refer the matter to an inquest in the face of strong circumstantial evidence. That's the first aspect that I considered when you got to look at the case holistically. That's the first aspect of the conduct.
Should we understand you to say that that was done in bad faith?
I think what with all due respect, you should understand me to be saying is that when we look at all of the conduct of Advocate Chauke in this matter, from that decision through to the SCA decision, almost compelling the national director to make a decision in 2 months in this matter, that I can't say what conclusion this inquiry will come to, but certainly in my mind, I was concerned that there may be other factors that was driving this behavior and these decisions at the various points in this process.
Other factors or circumstances based on supposition?
Circumstances based on other facts.
What facts?
The fact that there were 3 charges that General Mdluli was facing, and all 3 charges disappear, for want of a better word. They get withdrawn at various stages within, I don't know what time frame, but
I think it's incorrect in law to say that they disappeared. That those charges
I
were
agree,
withdrawn.
Chairperson. I
Let's
agree.
use the correct terminology.
I apologize.
Legally speaking, because somebody out there listening to us talking will think that we use those terminologies in court. Let's use the correct terminologies.
Point taken,
The
Chairperson.
provisional withdrawal of the charges do not bring an end to litigation. Just as simple as that.
Chairperson, getting back to the facts that I say, it was not supposition. It was facts. The fact is, the charges in respect of the fraud perpetrated by Mr. Mdluli were withdrawn. The charges...
But I beg your pardon, I'm sorry to interpose. Those related to the Mrwebi matter, and I requested you, counsel, that let us not conflate issues. We assist with the matter relating to Advocate Chauke. The fraud and related charges pertain to the Advocate Mrwebi matters. It has got nothing to do with Advocate Chauke, at least on the matter that is before us.
Chairperson,
And I request you to confine your responses to the matter that we assist with.
Chairperson, I was trying to answer your question. That was whether, what was it, there was direct evidence of mala fides. And then I said to you, there was a whole range of things that led me to come to a reasonable suspicion that there may have been ulterior motives in this matter. And then I was trying, and you said based on, if I may please finish this, please.
Okay.
And the judge then said it was based on supposition. And I said, no, not supposition. It's based on facts. And then I was trying to set out the facts. Thank you.
Up. The facts that you are stating do not relate to Advocate Chauke, correct?
Chairperson, they relate
fraud,
to
the fraud matter. As I read the record, those fraud issues or charges related to the representations that were made to Advocate Murwebi. And Advocate Chauke is not charged, if I may use the word, in relation to the fraud or the withdrawal of the fraud charges. Those matters were matters in relation to Advocate Murwebi. Am I correct?
Chairperson, you're absolutely correct.
I request you, Counsel, let's confine ourselves to those facts that pertain to Advocate Chauke so that we can understand the direct evidence that is suggestive of the fact that he acted in bad faith without bringing all sorts of other issues unrelated to him.
Chairperson, with all due respect, those are important aspects to be taken into consideration. And understanding that I am sitting in this chair as the national director, I have to consider various factors if indeed I want to take a decision to refer a prosecutor to disciplinary hearings in a matter. I must have a reasonably, I must have factors, I must consider all factors that lead me to conclude that perhaps there is an element of bad faith here. I have to, as the national director, consider all of these matters when I decide to make a decision on whether the matter should proceed to an inquiry or not. And with all due respect, Chairperson, these are important factors that existed at the time that I needed to consider in my decision-making process. And that is why I am bringing them to the attention of this inquiry, because I've been asked about whether they could possibly be bad faith. And I'm trying to answer that in the best way I can. And with all due respect, Chairperson, in my view, it's hard to then confine it just to this matter.
The second point related to the fraud charges. The first one was the withdrawal of the murder charges. The second point that you are talking about now are the fraud charges.
That is
you
correct.
Agree related to Advocate Murwebi.
That is correct. And the third?
Yes, madam.
And the third one is the one where the disciplinary charges in the South African Police Service was also withdrawn.
If my recollection is correct, this third aspect related to the disciplinary charges of certain police officials
General Mdluli.
within the SAPS.
General Mdluli, that is correct, who was in the SAPS.
Yes. Yes, you are. Let me just tie up on this. I don't want to lose this. And withdrawal of the disciplinary charges against General Mdluli. Is he a general? Mdluli?
He was at the time, Chairperson.
That has got nothing to do with Advocate Chauke.
That is correct.
It is the SAPS that takes a decision to discipline its own member.
That is correct, Chairperson.
Thank you.
Advocate Batohi, I had expected that in order to show bad faith, you were going to list the actions of Advocate Chauke in relation to the matter of Mdluli, to say Advocate did this 1, 2, 3, 4, which shows that he was not acting in good faith. But now you're bringing in outside issues, and I fail to understand how do you link this and try to show that they prove bad faith on the part of Chauke. I mean, of Advocate Chauke. The disciplinary charges, did Advocate Chauke influence the withdrawal? The withdrawal of the fraud charges, did Advocate Chauke play a role there? Because I expected you to give us a chain of events that would show us that Advocate Chauke, in his final withdrawal of these charges, was acting malafides.
Yes, thank you. I expected to do that myself, is to give these chain of events, but I get asked other questions in between, and then I try to answer those questions, and then I get off the chain that I was trying to go along. So it wasn't like I
Councillor,
was.
You have now been given a chance. You referred us to 3 aspects.
Thank you, Chairperson. So if I now get back to the chain that the Madam Baloy Mary is talking about, I was dealing with the different aspects of the conduct of Advocate Chauke that I couldn't really understand in terms of why he would take these decisions.
If I may, you gave us 3. Were you going to proceed to the 4th aspect?
Chairperson, those were 3 different aspects. That's why I say I was on a different path. I went into a trajectory, and then I gave you 3, but I'm going back to my first path. So the 3 that I gave you were the 3 cases that General Mdluli was facing at the time that were withdrawn. Going back to the aspects, different aspects of Advocate Chauke's conduct that I said I found difficult to understand in the circumstances was firstly the withdrawal of the charges. And the first one I dealt with, so I don't want to go into detail. Withdrawal in the face of strong circumstantial evidence, where your team is saying, notwithstanding this representation that alleges a conspiracy, we should proceed. That's the first issue. On its own, it might seem not too much of an issue on its own, but it is still, on the face of it, that is seriously concerning in those circumstances. The second aspect is the matter then proceeds to an inquest. The inquest magistrate findings are confusing, to say the least. In Advocate Chauke's response to my letter to him.
Pardon, madam. We are dealing with his bad faith. What the magistrate did or did not do has got nothing to do with him. Let's look at his conduct that manifests bad faith on his part.
With all due respect, Chairperson, what the magistrate found and his conduct after that is important. That's my point, is that given what the magistrate found and then what his conduct is after that, it doesn't make sense in the face of the magistrate's findings. So it's important that I explain that. If I may continue, Chairperson.
I assume then if this is the pattern, you are going to go to the SCA's findings in relation to the conduct of the magistrate.
Chairperson, I'm trying to answer the question. What were the various aspects of Advocate Chauke's conduct that led me to believe, and to use the language of the panel, that he was acting in bad faith? And my language was to lead me to believe that there may have been some other aspects at play here. I'm not sure why would a prosecutor in these circumstances make this decision? And then in order for me to do it, the conduct comes after the various court, and what happens in court, in fact, has got to be considered in the light of the conduct. So I have to deal with it. I'm sorry, Chairperson. I am as exhausted as you potentially are, but I have to deal with it in this way because otherwise it does not make sense, Chairperson.
Yes, Counsel, please, and I beg you, just tabulate those aspects of the bad faith on his part. I mean, you don't need to give a long context. You can just simply that he withdrew the charges in the face of circumstantial evidence. He did X. He did X. That's all that we need to know. We have read this record and we'll continue reading it.
So I'll try to be very succinct, Chairperson. The second aspect of his conduct comes about after the magistrate makes his finding. According to Advocate Chauke, and this is important, he says that the magistrate cleared Richard Mdluli. Now, that is not what the magistrate did. And this is important because the magistrate in the inquest findings, he in fact found the following. And it's important because it goes to Advocate Chauke's conduct in the face of the magistrate's findings. The magistrate states the following. And I'm going to refer to Murphy's judgment that actually quotes from the inquest.
Please to the judges or Mr. Murphy or Judge Murphy or Murphy J, please.
Certainly. Murphy J says the following at paragraph 74, referring to the findings of the magistrate. The reasons suffer a measure of incoherence, and the ultimate findings are contradictory. He found at first that an inference of Mdluli's involvement would be consistent with the facts, but not the only inference. And then he goes on to say, and I won't read that aspect of it. The point, Chairperson, is that the magistrate in the inquest findings went into great detail to deal with the evidence and didn't reject any of the evidence. And so what one would have expected Advocate Chauke at this point to do, now having received the inquest magistrate's findings, which does not say that there's no evidence against, which did not hear Richard Mdluli. It was at best very confusing. One would have expected Advocate Chauke at that point to do, well, he had a couple of options. One is he could have, on the face of that lack of clarity, asked the magistrate for clarification, or given the fact that the magistrate in fact said that, I want to make sure I use the correct language, that the inference of Mdluli's involvement would be consistent with the facts, but says it's not the only inference. I want to there were a couple aspects of the magistrate's evidence that would have made Advocate Chauke think that here's his team saying there's strong circumstantial evidence. Here you have a magistrate at an inquest that is actually saying that there's a strong indication that Mr. Mdluli is involved. One would have expected that he would have read that carefully, reassessed it, and in my view, considered charging him with murder at that point. But at that point, if we look at paragraph 89 of Judge Murphy's, he says, Chauke in his answering affidavit simply ignored some of the inquest findings, saying simply that the magistrate found that there was no evidence implicated in Mdluli. clearly there is evidence implicating Mdluli. So the magistrate's conclusion is anyhow not decisive, and it is guilt or innocence of the matter is for the trial court. So my point being, Chairperson, given all of this, one would have expected Advocate Chauke to reassess at that point and think about instilling in. Remember, General Mdluli is a police officer, and the interests of justice demand that there should be accountability if there's evidence against him. This is what happens after the inquest. Advocate Chauke then, nevertheless, doesn't act after the inquest, and then Full brings the application. We then
I
get
beg your pardon?
Freedom Under Law brings the application.
Advocate, but wait. Let's go to SB6, page 242, paragraph 7.
Sorry, if you can repeat that.
SB6, page 242. It's an annexure to your affidavit.
Mm-hmm.
Your submission now is that after the inquest, Advocate Chauke does nothing and FUL takes the matter on appeal.
If I may
On
just think
review.
about that. Let me think about that before
Okay.
I answer, because
Okay.
I think at that point, before Full brings it to, takes the decision, I think Advocate Chauke may have decided to proceed with the other charges and not the murder charge at that point. And Full probably, I think they brought the application after that. But I'm speaking, trying to remember, I'm not looking at documents, but that is my recollection of what he might have said
Go
and what
to
might have happened.
SB6, page 242.
SB6.
Yes, page 242.
214?
242, paragraph 7.
Mhm.
Remember, in your evidence, you informed this panel that Advocate Chauke was working with a team
Mhm.
that advised him on whether to proceed with the prosecution or not. Now, please read the first 4 or 5 lines of paragraph 7.
Sure. So to contextualize this is after the inquest.
Yes.
I then requested and instructed the prosecution team to enroll the matter in respect of the remaining other charges, yes, which is what I'd recalled now,
Mhm.
in which I was satisfied that there was prima facie evidence against the accused. The prosecution team, through its lead prosecutor, Advocate Van Zyl SC, hereafter referred to as Van Zyl, informed me that he had been informed that my decision to refer the matter to a formal Advocate Van Zyl, let me start again. The prosecution team, through its lead prosecutor, Advocate Van Zyl SC, hereinafter referred to as Van Zyl, informed me that he had been informed that my decision to refer the matter to the formal inquest to be conducted and the findings of the inquest will be or has been taken on review. He proposed that in view thereof, the prosecution team is of the view that we should wait for the decision of the High Court in order to avoid a situation where, if my decision is found to be irrational, etc., the trial will have to include the murder and attempted murder charges.
This is at the back of what you just submitted, that after the inquest, Advocate Chauke did nothing.
I did correct myself.
Thank you.
I beg your pardon?
I did correct myself before I read this, and I said, I think what he did is he decided to enroll the remaining charges, but not the murder charge. That was what my recollection was.
And he gave a reason why.
I would like to comment on this paragraph, if I may.
Please do.
So in this paragraph, there's nothing that I have a qualm with, because what Advocate Chauke is saying, that this is after the inquest magistrate has made a finding, and we talked about how confusing that finding was. Advocate Chauke then instructed the prosecution team to enroll the matter in respect of the remaining charges, not the murder charge, because he was satisfied that there was prima facie evidence. And that's the point, because Advocate Van Zyl then says to him, I'm paraphrasing what's written here, what Advocate Chauke is saying. Advocate Van Zyl says to him that he's been informed that there's a review matter with regard to the murder charge. And Van Zyl is of the view that in order to avoid the fragmentation, they should not proceed with with the remaining charges, but let's wait for the outcome of the review proceedings, which is absolutely makes sense, because we talked about the fact that these charges were so intricately intertwined that it would actually make sense to keep them together. So this was absolutely fine. But what this also shows is that when Advocate Chauke decided to enroll the other cases, he was satisfied even at this stage that he had good reason not to enroll the murder matter.
But Counsel, you have not read the entire part of paragraph 50.
Paragraph
50.
50.
Yes, ma'am.
Of which document?
The very one that you were looking at. That paragraph goes on to say
50 of SB6, Chairperson.
Yes, that is Advocate Chauke's statement.
That is
or
correct.
affidavit at the Zondo Commission.
Mm-hmm.
He deals with that aspect that my sister referred to.
Mm-hmm.
Now, when you read that paragraph in its entirety, you'll see towards the end that he acquiesced to what Advocate Van Zyl SC said.
Chairperson, I'm a bit confused. I'm not in the right spot. I'm not in where you are.
Yes, at SB6, 242, but it's the same paragraph.
Okay, I think it's the same paragraph, but let me take you then to his statement, which is almost similar to what was read to you. If you read it from his affidavit at the Zondo
Which is
Commission,
where?
His affidavit is ZC 01426.
I don't know if I have that bundle.
Your team will assist you with that one. As you look, maybe I should just read the entire paragraph, which is almost similar to what my sister, Advocate Baloyi, was saying. It is exactly identical, but you did not look at it to its logical conclusion. Paragraph 50. I then requested and instructed the prosecution team to enroll the matter in respect of the remaining other charges in which I was satisfied that there is prima facie evidence against the accused. The prosecution team, through its lead prosecutor, Advocate Z.J. Van Zyl SC, informed me that he has been informed that my decision to refer the matter to the formal inquest and the findings of the inquest will be or has been taken on review. He proposed that in view thereof, the prosecution team is of the view that we should await the decision of the High Court in order to avoid, that's the latter part, in order to avoid a situation where if my decision is found to be irrational, etc., the trial will have to include the murder and attempted murder charges. I acceded to this proposal and the matter was not enrolled. I attached here to an email from Van Zyl dated 19 June 2014, marked Annexure AC8. So Advocate Chauke says he then acceded to the suggestion made by Advocate Van Zyl, because the order of the High Court would have found that his decision was irrational, and to avoid that, he then agreed that they should then not enroll the matter, because the decision could have gone to the extent of the decision including the murder and attempted murder. So he says, I agreed. What is wrong about that?
Chairperson,
That approach?
firstly, just to correct, I thought that Madame Baloy Mera had asked me to read the first 7 lines. So I may have been mistaken and didn't hear properly.
Well,
so
the entire paragraph reads
it's
for
relevant.
itself.
I agree.
Yes.
And Chairperson, as I said, my answer remains the same. I have no qualm with this approach at all, because what Advocate Chauke, in fact, what he had decided to do after the inquest, according to this paragraph that you've read, is he decided to enroll all the charges except, he says, to enroll the remaining charges in respect of which he was satisfied. That means the ones, not the murder and the attempted murder, it seems. And Advocate Van Zyl, as I explained, said to him, let's not do that, because this matter is on review. In the event that the court finds that your decision was irrational, we can then proceed with all the charges, because it made sense to keep them all together. And so at this is absolutely fine. I agree with this approach.
And he says,
And
I agreed.
he did. So he did. The important point about this, though, is even at this stage, after the inquest findings, Advocate Chauke feels that the murder charges, there's not sufficient evidence to proceed on the murder charges. There's now a review.
What is wrong with that? He's being advised by senior counsel, and
Chair-
he agrees with the opinion of senior counsel.
Chairperson, the only thing he's been advised about is to keep the charges together. He's not being advised about the issue of the Advocate Chauke's decision not to prosecute the murder matters is not an issue that he's being advised about. Advocate Chauke had decided to proceed with the other charges and not the murder one. Advocate Van Zyl says, rather not proceed with those charges, let's wait for the outcome of the High Court.
But at that stage, the murder charges were simply withdrawn, and they could be reinstated at any time should there be evidence that satisfies Advocate Chauke that he can proceed with those murder charges.
That is it. Advocate Chauke was not satisfied, even at this point. But you're absolutely correct. It could have been enrolled. He could have enrolled it at this point after the inquest. He doesn't, because he's still not satisfied that there's sufficient evidence to charge. And that is, I question that decision. So that's the second point at which Advocate Chauke had an opportunity to reconsider. The matter is now in court in the full application before Judge Murphy. Judge Murphy's judgment I've read. I'm not going to read it again. But what is clear from Judge Murphy is that I'm definitely not going to read the entire judgment. 1 or 2 points that at this, the point I want to make, Chairperson, is even after Judge Murphy is very critical of Advocate Chauke's conduct, and is critical of the magistrate. Sets aside the decision, reviews it, and he sets aside the decisions. And he directs Mwebi and Chauke to reinstate the prosecutions and the National Commissioner to reinstate the disciplinary inquiry. Those were all subject, but we'll deal only with the Chauke part of it. So at this point where Judge Murphy is saying, you got enough, reinstate, what would one expect a prosecutor in the position of an experienced DPP to do? Your team is saying prosecute. You got strong case, circumstantial evidence. You've got a representation that talks about a fanciful conspiracy against you. And now you get Judge Murphy saying reinstate. Advocate Chauke does not. He refuses to reinstate. They take it on appeal to the SCA. And that is my question. At every step, I would think at this point, why would you appeal Judge Murphy's decision? Why not prosecute the murder charge at this point?
But if the SCA then absolves him and say there was nothing irrational about his conduct, you remember Judge Murphy said that his decision was irrational. The SCA decides otherwise and says there was nothing irrational about his conduct. So his approach to the SCA or the NPA's approach in appealing the decision based on the decision of the SCA was not wrong.
Chairperson, I have explained my understanding of that decision and the circumstances. I do not believe it dealt with his decision on the correctness or otherwise of Advocate Chauke's decision at various stages to prosecute the murder matter.
I mean the SCA.
Yes, let me rephrase that. I have dealt with this issue, I think, twice, and the inquiry is aware of my understanding of that decision.
We need clarity. That's why we keep on going back to it, because the fact that we ask you to assist us and clarify this aspect, we clearly want to understand your position of these matters, because we don't want to make assumptions after the event and we struggle to write a report because we did not afford you an opportunity to state the position as you understood these judgments.
Yes, thank you for that, Chairperson. I appreciate that. The panel has afforded me the opportunity twice to do that, and I cannot clarify it any further. I would ask that the matter be left for argument, Chairperson, with all due respect.
Can I ask my last question? And I promise it will be my last question. Is the NPA precluded from taking a matter on appeal if they feel or if they see that the judge's decision is based on reasons that they do not agree with?
Chairperson, it shouldn't simply be reasons that you don't agree with. It should be for good reason.
Let me rephrase, for good reason.
If it's for good reason, then of course nothing precludes you from doing that.
My last bit on this, Advocate Chauke says, in any event, I'm just paraphrasing what he's saying, at the end of the day, the final decision was that of the NDPP. That was your decision. As the head, be it you or Advocate Jiba or the NDPP then, he says the final decision was that could be made by the NDPP on these matters.
Chairperson, I'm trying to understand which final decision you're referring it.
The
Is the
final
decision-
decision to, I suppose, to reinstate the charges or to act in accordance with paragraph 3 of the SCA judgment. I assume that's what he's saying, but if he's not saying that, I'm putting it to you that given the order of the SCA, the final decision was that of the NDPP.
That is correct, Chairperson.
Thank you.
Chair, yes, due to the lateness of the hour, I just want to indicate that maybe it would be better that I ask my question tomorrow.
Advocate Ramachacha would like to I'm not sure whether to follow up on this question, but she will reserve her question for tomorrow because it is now 10 to 5. Advocate Mutlamunyani, please bear with us. This engagement with Advocate Batoyi helps us to understand precisely what her case is, so that when we finish this hearing, we should know precisely what her evidence is. We will adjourn until tomorrow morning at 9 o'clock, and Mera Makhacha will start with the question. I beg your pardon. I see you had a conference with your colleague, Advocate Chauke there. I will afford you a chance to talk to him.
My co-evidence leader, Madam Chair, informs me that I should inform the panel that tomorrow he and Advocate Skosana will not be here because they'll be doing other duties. They'll actually be consulting with a witness.
It appears to me that your team is disappearing from this venue. And yet, they were appointed precisely to assist you. You know where we come from.
I know, Madam Chair.
You know the challenges that we have encountered with you being the only evidence leader.
Yes.
And now you have a team. Tomorrow you'll be sitting alone, it appears.
They are consulting tomorrow, Madam Chair. He and Advocate Ntweni and Advocate Skosana SC will be consulting with a witness who is going to be called to this hearing.
Advocate Mutlamunyane, I wouldn't want to be instructive as to how you should proceed with this matter. But you know that there's still going to be cross-examination here. And I would have imagined that you'll take advantage of having an assistance from Advocate Ntweni, whilst Advocate Skosana is busy consulting. But if both of them are going to be out of here, I foresee challenges that we had before. And I think in all fairness to you, Advocate Ntweni must be here, at least until Advocate Batoyi is done with her evidence.
I confer with him.
Yes, please.
He says he will be here, and Madam Chair.
Thank you, Advocate Ntweni. You should be here to assist Advocate Mutlamunyane. You can see the bundles of evidence that we are referring to. And in fairness to him, he needs an extra hand to assist him with all these documents. A consultation will follow, at least at the end of Advocate Batoyi, because she also needs to be assisted with the documents that counsel or ourselves are referring to. Please be here tomorrow and the subsequent days until she finishes.
Madam Chair, I was very pleased to hear that my learned friend needs an extra hand. We just want to record that we've been blue-ticked by the state attorney on asking for the extra hand.
Counsel, I suppose you are out of order. That is not a matter within the space of the panel. When you were appointed, the panel was not involved. I think it's a matter that you should take up with the state attorney. But I'm looking at all of you. It's a team of 4 here, team of 4 lawyers, senior lawyers for that matter. So that matter can be taken up with the state attorney, senior counsel.
Thank you, Madam Chair. I'm not taking it any further.
counsels Advocate Batoi and Advocate Chauke. We will adjourn and reconvene tomorrow at 9 o'clock. We adjourn. Thank you.